Good morning. Good morning. Hey, loud talkers. Let me know if you guys can hear me. It's all early in the morning. Put a thumbs up all in the chat if you can hear me. She said, good morning, chat. Free Holly, the hero. Thank you, Totally T, for the super chat. Appreciate you. She said, yes, we can hear you. Thank you, thank you, thank you. Thank you, Truth Be Told. She said, good morning, family. Send love from Tennessee. I love it here. Thank you, Truth Be Told. Appreciate you. And welcome in, welcome in, welcome in. I'm so sorry I couldn't come live last night. Your girl was beat, baby, beat. I was tired. I did 2 lives the day before and I was just beat. So, but anyway, good morning. I know you guys are not used to hearing me this early in the morning, but I am here. Thank you, big sis Glenn. She said, good morning. I'm about to drive to my dentist appointment, but I'm listening. Okay, girl. Hope everything works out. Monica said, we missed you yesterday. Yes. Girl, I crashed. I was in the bed before Jay, so y'all know that was super early. Super early. Anyway, I got to tell y'all about what happened in court yesterday. I'm going to tell y'all about what happened in court yesterday and what it means moving forward for the Holly case, you guys. So, did y'all drop those white hearts in the chat? Did y'all drop those white hearts in the chat for Holly, baby? Holly is maintaining her strength, honey. She know that we're out here advocating for her. She knows that we are wishing her well. And yeah, she knows. Her family is definitely letting her know that we are still here standing in the paint for her, okay? All right. I see the white chats. Thank you, thank you, thank you, thank you, and thank you. Appreciate it, appreciate it, appreciate it. So let's get into it. So yesterday, Holly went to court. And if you are anywhere in the YouTube streets, and I'm talking about anywhere in the YouTube streets, or if you really advocating for the case, hey, you guys, please hit that thumbs up button for you, girl, please, and thank you. But if you guys are anywhere in the YouTube streets, or if you are really advocating for the case, or keeping up with the case, should I say, not advocating, but keeping up with the Holly and Ramika story, you already knew that she was not getting out yesterday. Hold on one second. I'll be right back. Hold on one second. Sorry, you guys, I got my cup of coffee, but I forgot to get my water. All right, so if you, like I said, if you are keeping up with the case, then you already know that she was not getting out yesterday. It was literally a status update case, not case, but hearing yesterday. Just a status update, okay? As I've already told you guys, her case went before the appellate judge, or hasn't went yet, but it is up there going before the appellate courts. And until the appellate court responds with their answer, then Holly will remain in detention, okay? So again, until the appellate courts, they've already accepted her case, but until they review it and answer it, provide whatever answer it's going to be, whether they're going to, overrule what the state said or not, then she will be there in detention until her day in court, okay? So, and if you are following this case, you should have already knew that. If you didn't know, that means you're really not following the case. You're just out here making noise, So anyway, but yesterday they went to court, and Ari, the defense attorney, requested for Holly to be put into protective custody, okay? And the judge granted her that order. So Holly will be put into protective custody instead of being in what do you call it? Public population, or with everybody, right? So she's there in protective custody. And let me just tell you why protective custody is necessary right now, okay? This is a high profile case, if you guys didn't know that, right? It is a high profile case, and in a high profile case, the defendant is normally a target. Yeah, general population. Thank you so much, general population. Yeah, so instead of being with general population, she will be in protective custody. And the reason being, one, this is a high profile case. But two, there's a lot of people that really want to harm her. And let's talk about that for a minute. Why do they want to harm her? Well, because of the narrative that's out here on social media and throughout everywhere, right? The narrative that she is a murderer. People are literally calling her that without her being tried and convicted, okay? Now, here in the United States, you are innocent until proven guilty, but not with some people, honey. Some people don't even abide by the laws whatsoever. They just say, you know what, the hell with it. She is a murderer. So they are calling her a murderer. They're not even allowing her to tell her side of the story at all, right? Because she has not told her story. And but it's coming. Trust me when I tell you it's coming. So right now, because they have deemed her a murderer, it is people that want to harm her. So with that being said, the attorney asked and the judge agreed for her to be in protective custody. So that is where she will be until she gets out, until they release her. If the appellate court comes back and say, yeah, you know what, there is a way that she can get out. Some of these restrictions they have out here, whether it's GPS monitoring or house confinement or restraining order, or whichever one, or all of them, right? But most likely, but I'm not going to say 100%. I'm just going to say most likely they will reverse it and she will be released home, okay? However, she said, I was in protective custody when I was locked up. Oh, were you? And so I looked up protective custody in Illinois, and let me just tell you what that means, okay? Hold on one second. For the state of Illinois. I looked it up and it said, so I think a lot of people, even myself, to be honest with you, I thought protective custody was like, what is it called when you lock down for 23 hours a day? Solitary? Is it called solitary? So I thought that's what protective custody was kind of like, but it's not. Protective custody is actually, you're just away from the general public population, and you are, and it is different. Sometimes they may have you with like 10 people. Sometimes they may have you with like 2 people or whatever, but she will be isolated for a good bit of time. However, it's just in like a smaller cell, okay? So I thought it was like, solitary confinement, like this dark room, and she'll just receive food through a door. And, that's what I was thinking it was. But basically, it is just a smaller cell where they have other people there. They may have like, I don't know, however many people or whatever. She said I was locked up with 23 hours and had a cell by myself. Oh, okay. You were locked up for 23 hours? Oh, wow. Okay. So, but yeah, you may have your own cell, or you may have it with 2 people, or I think you may have your cell by yourself or with another person. But when you come out in like the break room area, and I know it's not called break room area in jail, I don't know what it's called, but whatever it's called in day room, y'all know what it's called, the general area or whatever. It may be only like 10 people or so. So it's not going to be like a bunch of people. And mind you, she's not in prison. She's in county jail, okay? County jail. And this is pre-trial, so she has not been convicted of anything, okay? Let me just say that again. Not being convicted of anything. So she is not in prison. So I hear people saying, oh, she's locked up and she's never getting out. Well, we haven't even been to trial yet, okay? So, so they asked for protective custody. The judge granted it. And then the state attorney turned around and asked for a buccal swab, okay? And that's just a swab in your cheeks for DNA, how you want to find out if it's your child or not, or if your son's child or not, or whatever, and you go swabbing the kid's mouth. So she was ordered that yesterday as well. So, and from what I've heard, and I heard this from Tia Urines or whatever, she said that she think it has something to do with the weapon. I think they want to match Holly's DNA to the weapon to make sure that she's the one that fired the weapon. Okay. Now I would have thought that they've already done that. However, they haven't done it yet, apparently. So, and that's what it's for. Okay. So, and that's pretty much the only thing that happened yesterday. It wasn't a whole lot that went on or whatever. So that's the only thing that happened. So she will be in protective custody instead of general population. And the state got her DNA yesterday. So, but I owe you guys something. Someone sent me a case study regarding this case. And they were like, Amora, look this up, look this up, look this up. So of course, I did my homework because that's what we do over here. We don't just rely on what everybody else is saying out there in the streets. We do our own homework. We do our own research, okay? And we research the law. We don't just listen to this is and that, so whatever, and take it and run with it. We literally do research over here. So with that being said, I looked up the case study and I would like to go over it with you guys to tell you how it will apply to Holly's case, okay? Now, first of all, before I get into this case study, have anybody heard of it? It's the People versus McGraw. Raise your hand if you heard of People versus McGraw. It was out of the state of Illinois long time ago. I think 1958, if I'm not mistaken. Have anybody heard People versus McGraw? I'm going to get into it. But before I do, I'm going to bring it up here too. Give me a second. Before I get into it, I want to go over some things before I get into this one, right? As far as evidence right now, okay, the only thing that we know about, the evidence that we know about is what has been spoke about in court, okay? And that is, for the defense side, it is the CTA bus footage, the Sharks bus footage, not bus footage, I'm sorry, the Sharks camera, and also the 4 pod cameras, police pod cameras that was out there. And also, well, of course, witness number 1, because he was on the scene. And then Holly's side of the story, right? And I'm trying to think of anything else. I think that's all we know of right now. And as far as the state, from what they have brung out in court, is the witness statements. So witness 1, 2, 3, 4, and 5, which we've heard that witness 4 has withdrawn, but the state haven't made it public yet. But nevertheless, witness 1 through 5 statements, the pod camera, and also the camera footage that I just mentioned as well, the Sharks, and I want to say maybe some other restaurants in that area, okay? Now, and then, of course, the ballistic report, the autopsy report, the medical examination reports, and things of that nature, all right? So any other evidence I have not heard of, okay? That's the only evidence that I have heard of thus far. I've been listening, trying to figure out, because everybody, well, not everybody, but some people are saying, oh, the state has all this evidence. The state has all this evidence. And I'm like, okay, where is the evidence? Where is the evidence? Because as of right now, unless there's more, as of right now, the evidence that has been presented definitely leaves reasonable doubt, a lot of reasonable doubt, okay? And I've said this before, and I'll say it again. Unless there's more evidence that we don't know nothing about, then it's going to be a hard pill for the state to swallow, okay? So let's get into the People versus McGraw. We're going to bring that up. Again, this was given to me by actually a supporter. She said somebody came up on their platform and they spoke about it on TikTok. And she wanted me to discuss it over here. And I was like, sure. She's probably not even in the chat. She's just going to have to run this one back, though. Hold on 1 second. It is an old case study, but it is dealing with self-defense. Okay. Well, I was going to bring it up. I'm just going to read it. All right. Well, no, I'll bring it up. Let's bring it up. All right. So this is the case study that will be applied to for Holly's case. How do I know that? Well, because it's a self-defense case. It's a self-defense case. And this case study always comes up in a self-defense case in the state of Illinois. All right. So I want to read this case study because it has a lot to do with people that is claiming self-defense when there was no video footage and the victim was unarmed, okay? Because a lot of people seem to think that because a person is unarmed, you are not allowed to use lethal force. And that's just not true. So, I mean, I'm pretty sure I've said that 15,000 times, and I hope I don't have to say it 15,000 more times, okay? So, again, this case study is about a gentleman. I'm going to read it. But, you know, it was involving a car accident. Let me just read it. All right. So this is the Supreme Court of Illinois. This happened March the 20th. Well, actually, it was filed March the 20th of 1958. Okay. I know that's a long time ago. However, this case study is still being used to date. Okay. So let me give you a brief of what happened in this story before I read this right here. So this gentleman was involved in a car accident, okay? And during the car accident, the police came to the scene. Somehow he got involved. Let me see if this is talking about it. Oh, yeah, it does. It does. Okay, so I don't have to say it off the top of my head. All right. So Supreme Court of Illinois filed March the 20th of 1958. So even though this gentleman was found guilty by the state of Illinois, by a jury of his peers, he was found guilty and sentenced to 14 years in prison. Okay. However, they took his case up to the appellate court, and the appellate court overruled his conviction, and he was freed. And I'm going to tell you why in a minute. All right. So here we go. So it says the gentleman name is, I know his name is McGraw, but I'm trying to figure out what his first name is. Livingston McGraw. So it says this is an appeal by the defendant Livingston McGraw from a conviction of murder in the criminal court of Cook 251 County. He was tried by a jury, and the court entered judgment on the verdict, which fixed his punishment and imprisonment in the penitentiary for a term of 14 years. Okay. So he was sentenced for 14 years. Okay. The indictment for murder arose out of the undenied, which means he did not deny shooting a police officer. Okay. A Chicago police officer. So it arose out of the undenied shooting and unaliving of one Richard Rashawn, a Chicago police sergeant. So the guy name was Richard Rashawn. And hopefully I'm saying his name right, okay? But a Chicago police officer, following an altercation over a slight collision, a motion for directed verdict at the close of state's evidence and at the close of the case was overruled, okay? After verdict, a motion for a new trial was made. The defendant then withdrew motions for the new trial, said, nah. So once the jury came back and said guilty, and he was sentenced for 14 years, they asked for a new trial. They did a motion for a new trial. Then immediately the defendant and his attorney withdrew the motion for a new trial with leave of court, filed his motion to set aside the verdict and to enter an order discharging him on the ground that the evidence was insufficient to support the verdict and that he acted in self-defense, okay? So the state contended that since the bill of exceptions lacked a motion for a new trial, the court is precluded from reviewing the sufficiency of the evidence to sustain the verdict. I just dropped my goddamn coffee. Hold on 1 second. I don't know if y'all can hear me though, but I have my iPad, but I gotta wait to go back into the office because the iPad, I can't read the case. I can't pull it up and have this, you know what I'm saying? I can't, yeah, my iPad is not that big. But anyway, I just thought you guys would enjoy the breeze with me until he finished cleaning up the coffee and with the wires. She said, pin your coffee link, please. I'm gonna have to do it when I go back in. I have to do it when I go back in. What is this? I don't know what that was. What is that? New to the streaming? Oh, I don't know what that was. Let me delete that. I don't know what that was. But anyway, we're going to get back into this case study. But let me just tell you what I know about it right now, just off the top of my head, because I did read it. So the officer, he had a weapon, right? The officer had a weapon. But when him and the guy got in an argument, and I hope I'm not telling the story wrong, but when she said, listen to Jay. Wait a minute. Y'all can hear Jay? Is he in there talking? Girl, I hope he ain't in here talking. Not on my live. Not on my live. Get off my live. Get off my live. Get off my live, Jay. If you can hear me, get off my live. But anyway, now I'm going to wait. I'm going to wait till I go back in there because I don't want to tell y'all wrong. But it definitely applies to the Holly case, and we're going to talk about it in a minute. Hopefully he knows that I'm outside. I'm sure he does. The coffee got on some of his wires, and y'all don't know if y'all know my husband. A lot of y'all probably don't, but if you're new to my channel, you probably don't know him. If you old to my channel, you've been here for a while, you do know him, and he's OCD like hell. So yeah, he probably think, you know, damn house gonna burn down or some shit. You know, that's just how Jay is. Hey, but you gotta love him though. You gotta love him. You gotta love him. She says, no, I don't hear Jay. Oh, okay, good. She's talking about some Jay. Well, that's somebody definitely from day one, or, you know, been here for a while. Christina. Y'all, it's too cold to get in this pool, but baby, wait till it warm up. I'm gonna be out here in this damn pool. But it's cold. It's breezy. It's not freezing out here today. If it was, I definitely wouldn't be out here. Good morning, everybody. Good morning. I'm just waiting on Jay, y'all. For those that are just coming in, I'm waiting on Jay to... I got to turn off the computer. Okay, whatever. Have y'all seen my backyard? Let me show y'all my backyard. This is my backyard. It ain't much, but it's a backyard, baby. It's a backyard for your ass. It's a backyard for your ass. She said, you guys didn't get any snow. No, unfortunately, no. She said, a more house voucher, the lies they spread around. Good view. House voucher? Girl, what? Wait a minute. Hold on. Please don't say they said I got a house voucher, like a Section 8 voucher. Girl, stop. Hey, did somebody say I had a house voucher? Girl, I ain't heard of that one. That'll be a new one. I wish. Tell me where I can go sign up. Hell, why you playing? If I can get one, I sure would. God, a house voucher. They'll say anything. I tell you, people need to cut it out. Well, if I got a house voucher, I think everybody with a house voucher should be mad. Go get theirs. She said, yes, some more. They said you had a house voucher. Are you serious? Wait a minute. She said, yes, I'm more. That summer mama chick said that. You got to be kidding me. You got to be kidding me. You got to be kidding me. Oh my goodness. Baby, bye. Unfortunately, I've never had one in my life, but if I could have, trust me. She said, be your own people. I know, girl. Hey, Vera said, I need a voucher too. Hey, Vera said, I need a voucher too. Baby, well, my house voucher allows me to see palm trees, baby. I see palm trees over here. Let me show you my other palm tree. Well, we got quite a few palm trees, but look at that. This house voucher allows you to see palm trees, baby. Shy house voucher. Well, whatever. I guess whatever make her feel good. She talking about they don't show shit. Of course they ain't gonna show nothing. They ain't gonna show nothing. She said, if a voucher can get you that, then where do I sign up? Okay, Marissa. That was the first time I ever heard that, a house voucher. Oh my God. That is too funny. Well, I'm gonna enjoy this house voucher then, baby. She said, yeah. Summer mom said, gotcha, house voucher. She must be on Section 8. Yeah, because who even calls it a house voucher? Is it even called a house voucher? Hey, how do people know about a voucher in the damn first place? Did she say a house voucher? She got a house voucher. And she telling on her damn self. She got a house voucher. Okay, girl. Well, it's all good, baby. She said, I heard the truth uploaded more text messages. Oh, she said, is that true? I don't know if it's true, but if it is, we're going to talk about it tonight. Listen, y'all going to keep on pushing my other story back. Shit, that dude will be found guilty by the time we do that story. His ass will be sentenced by the time we do his story. What's the guy name? Jalen? Is it Jalen? Jalen, what's the last name? I can't even think of it. Pendergrass. Jalen Pendergrass will be in jail by the time we have his story. She said, did your voucher dig out your in-ground pool? I want one bad. Do tell. Hey, shit. Or did the voucher get me a spa and a fireplace too? Girl. I don't know. If a voucher put me in a neighborhood like this, then I'll take a voucher any day. You know what I'm saying? If a voucher put me in a neighborhood like this, yeah, no. People just talk what they don't know. They just get mad. I come out here and read the facts, and then they gonna make up shit. I guess they tell what makes them feel good. Oh, thank you for helping me reach my goal. I can't even play no music on this iPad. Hold on. Let me see. Can I? Can I? Can I? Oh, I think I can. Hold on. Oh, it ain't playing. Oh, is it? Oh, yay! One time for the house voucher. One time for the house voucher. Two times for the house voucher. Yeah, two times for the house voucher. Oh, my goodness. It ain't playing like I wanted to. There we go. There we go. There we go. Hold on. Hold on. Yeah, baby. Yeah, yeah, yeah. All right, hold on. Thank y'all so much for helping me meet my goal. Thank you, thank you, thank you. Now, Jay said it was only going to be a moment. 39 more pages have been submitted. 39 more pages? Oh, my goodness. We may have to finish up talking about this case law and go right into that, baby. We might have to spill that tea early. Let me go see if my husband is finished, y'all. Hold on. Darling. Back door closed. Back door closed. Back door open. Back door closed. Back door. Are you still at it? You still at it? But babe, you ain't gotta do all of that. Because but then be here, you said at 11:30. Babe, can you just please clean the desk and Okay. How much longer? Just tell me. How much longer? All right. Jay said it'd be 10 minutes. Shit. I'm gonna sit down on this couch then. I just can't read the case because I'm on well, I could get my phone. All right, hold on, y'all. Let me go get my phone. I could just read the case off of my phone. I know, but in 10 minutes I could be reading the case. I owe you. All right, y'all. Let me pull this up. All right. I need some light in here. All right, I'm gonna turn this camera off. Ooh, I don't like the way that look. Give me a second, y'all. I hope y'all can hear me because my iPad is not as loud as my microphone. So hold on. Where's my other picture at? All right, there we go. There we go. There we go. All right. So let's get into this case law, y'all. McGraw, People versus McGraw of 1958. All right. Let me know if y'all still with me. I came back in the house. So she says, wait, who submitted 39 more pages? Girl, we gonna find out in a minute, baby. We gonna find out in a minute, child. We gonna find out in a minute, honey. Yes, we are. Oh, come on. I had to pull it back up again. Okay. All right. So People versus McGraw, 1958. It was an Illinois Supreme Court case in which Livingston McGraw appealed to Cook County a murder conviction. The court examined if a fatal shooting was justified in self-defense after the victim. Oh shoot. Hey, what's up? You call me, but I'm on live. Okay, hold on. And who was this filed by? He put in 39 more pages for real? God damn, he gonna tell us all their business. Okay, I'm here for it. Oh, okay. Okay. All right. That's fine. Okay. All right. Bye. Well, yeah, honey. Robert done uploaded 39 more pages. We'll read it though. But let's get back into this tea. All right. So it says the court examined if a fatal shooting was justified self-defense after the victim, uh, Rashawn, assaulted McGraw following a traffic dispute. Okay. So, meaning the officer assaulted the shooter. Okay. The court focused on evidence regarding the reasonableness of the force used. Okay. It says Livingston McGraw was convicted of murder in a criminal court of Cook County following a jury trial. Rashawn became enraged over a perceived car swiping incident, repeatedly accused McGraw and assaulted him by slapping and beating him and forcing him to his knees. The Supreme Court of Illinois reviewed whether the circumstances justified fatal shots fired by McGraw. The outcome was the conviction was reviewed by the Supreme Court in 1958. All right. Let me go into it a little bit more. If it'll come up. Come on. All right, it's coming up. So, I already told y'all he was indicted on murder and blah, 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 right? It says the state contended that since the bill of exception lacks a motion for a new trial, the court is precluded from reviewing the sufficiency of the evidence to sustain the verdict. The purpose of a motion for new trial is to give the trial court an opportunity to pass on alleged errors. Here, in this case, the defendant takes the position that he did not want a new trial at all, and there was no reason to ask for one. After leave of court first had, he filed a motion challenging the sufficiency of the evidence and alleging no other error. Okay? So no objection was made by the prosecution to the procedure in the trial court, but it now objects to the defendant's rights of review. In this case, we hold that the trial court had ample opportunity to and did pass upon the sufficiency of evidence not once but 3 times, and to invoke the rule that the defendant is precluded from reviewing under the circumstances here presented would be manifestly unjusted. Let me get to the good part, honey, because I don't know all this other bullshit or whatever, right? Let's just get to the good part. Let's get to the good part. All right. So it says the defendant was driving a bomber type city garbage truck south of South Parkway, just south of 63rd Street in the city of Chicago. Rashawn, in plain clothing, so the police officer had on plain clothing, was proceeding in the same direction in his personal Dodge automobile. Without knowledge of McGraw, his truck scraped the rear fender and door of the police officer, causing damage variously estimated from $5 to $20. Now, this is back in 1958, okay? So anyway, it caused damage that was about $5 to $20 worth of damage, right? It was minimum, okay? However, police officer got mad. A northbound motorist indicated by signs to McGraw that someone following was trying to gain his attention. McGraw parked at the curve of the west side of the street, several hundred feet south of 63rd Street, and walked back to meet the police officer. The latter parked his car about 5 feet east of and parallel to the west curve and walked south a few feet where he met the defendant. While there are minor discrepancies in the testimony as to the happenings from the time of their meeting to the actual firing of the fatal shots, the record established the following facts: that the police officer became very, it says incest, whatever that means, and repeatedly accused McGraw of deliberately sideswiping his car. So the police officer became mad, right? And started telling the motorist, you swiped my car on purpose. You did this on purpose or whatnot, right? So it says, hold on. Did I miss my spot? Okay, so he said that he sideswiped his car on purpose. This was denied by McGraw, who indicated they could straighten the matter out without trouble. Okay, like, calm down, dude. We could handle this like adults. But the police officer finally became so aroused that he slapped or beat the defendant about the head and dropped later to his knees. Now, this is exactly how it's written, okay? All right. Wait a minute. Do we have somebody in here that needs to be out? Oh, okay. My bad. I thought somebody was being rowdy in the chat. All right. So this was back in 1958. So they say words that are kind of really crazy. All right. It says, so the police officer slapped him and brung him to his knees. All right. So McGraw, after having been hit several times, told the officer that he would not be doing this if he didn't have a gun. Thereupon, the officer went to the street side of his car and took off his belt and holster containing his revolver and placed them in the driver's seat. He returned to the front end of the car and again approached McGraw, either again striking him or attempting to. A bystander by the name of David Mazielish got between them as a peacemaker and suggested that they not act like children and let him straighten it out. Well, while the officer was talking and arguing with Mazielish and others in the crowd, McGraw went to the officer's car and got his revolver, got the officer's revolver. He had difficulties in getting it from the holster and the belt fell to the pavement. After removing the gun, he went past the left front fender and made a remark which was variously described as, "Now I am in command, and I am the one on the end of the gun, and now I got the big end of the stick." The defendant testified that he said, "I've got the gun now." The crowd too yelled, "He got your gun, he got your gun." The officer was at this point standing near the curve at the right front fender of his car. McGraw had walked up from the left side of the car to a point near the left front fender. There's no question but that the deceased was the aggressor. All eyewitnesses, both from the prosecution and the defense, testified without exception that the officer struck all the blows and the defendant offered no resistance at any time, and that his first aggressive act was the procurement of the gun. So his first aggressive act was going to the police car and grabbing the officer's weapon. Okay. So they said before that, he was getting punched and slapped in the head. All the witnesses said it. Okay. It says, let me go back. The only real question is whether the evidence established the guilt of the defendant beyond a reasonable doubt in the view of the defendant's plea of justifiable self-defense. Despite the fact that a large crowd was attracted by the altercation, variously estimated. Okay, thank you, baby. All right, I can go back into my office now, but hold on one second. Despite the fact that the large crowd was attracted by the altercation, variously estimated from 25 up to several hundred people, the state produced only 2 eyewitnesses that actually saw the shooting. Okay. So one guy named was Joseph, whatever the last name is, testified that he was in a car parked near. Let me go back to my office because I'm trying to hold my phone and it's small. Let me go to my office where I can make it bigger. Are y'all still with me with this damn case, y'all, with this shooting? Are y'all still with me? All right. All right, so right now it says there was no question but that the deceased was the aggressor. All eyewitnesses, both for the prosecution side and the defense, testified without exception that the officer struck all the blows, that the defendant offered no resistance at any time, and that his first aggressive act was the procurement of the weapon. All right. The only real question is whether the evidence established the guilt of the defendant beyond a reasonable doubt in view of the defendant's plea of justifiable self-defense. Okay? So, despite the fact that the large crowd was attracted by the altercation, variously estimated from 25 up to several hundred people, the state produced only 2 eyewitnesses to the actual shooting. Okay? You know how it could be a whole crowd of people out there, right? And somehow people, I ain't see nothing, I ain't hear nothing. And then all of a sudden, only 2 people want to make a statement. That's just how that goes, okay? So a guy named Joseph testified that he was in his car parked near the one here involved, that the defendant fired 2 shots and the deceased fell face forward about 5 feet from the curb and 8 feet from the defendant. The latter then walked over, pointed the gun down, and fired about 4 more shots down on the deceased. So this guy shot 6 times, y'all. And I'm not laughing at he shot him 6 times. I'm just like, God dang, you would think that that was absolute murder, right? But follow me, okay? Because it's not about what you did, it's about what you can prove. But let's continue. So nevertheless, so the guy, McGraw, walked over after shooting him 2 times. He walked over, pointed the gun down, and fired about 4 more shots into the police officer. The defendant then replaced the gun in the car and began pleading with bystanders, but the witness could not hear what he was saying. The second witness, his name was Virgil, a Park District detective, testified that he was driving north on South Park, and when 35 or 40 feet away, he saw a man with a revolver pointed at a 45 to 50 degree angle to the ground firing, and that he heard 2 to 3 shots. The man ran back to his car, threw the gun in the window, and then ran back to a multitude of people gathered there. The officer procured the gun, placed the defendant under arrest, and took him to the officer's car. The defendant said to him, "Officer, I had to shoot him because I could not stand to be hit on the head anymore." The officer then went back to pick up the belt and holster and left defendant with an unarmed bystander. He saw the body of the deceased lying face down against the west curb with his head facing south. The only other witness called by the state who was at the scene just prior to the shooting was the witness Mazilish. I think that's how you say his name. He testified that at the time McGraw started toward the car resolutely to get the gun, he ran and hid behind a shoe shine stand where he heard from 4 to 6 shots, which was fired without hesitation between them. He then went out and saw the falling officer lying about 2 inches from the curb. Now, do I want to finish reading all this? I'm going to skip some stuff, okay? And I'm going to get down to why his case was overturned, all right? Because this is too long. Let's get down to the real nitty-gritty. This went to court. He was charged and convicted of first-degree murder, right? But they took it up to appellate court, and this is what the appellate court said. After reviewing all evidence, including that of the peaceful reputation of the defendant, we entertain not only reasonable but grave doubt as to guilt. His actions immediately following the shooting were those of a man who felt that he had done something which he thought he was forced to do. He immediately told Officer Poole, who arrested him, that he had to shoot because he couldn't stand to be hit over the head anymore, and asked Poole to get some of the people's name so that they could tell how it happened. He apparently did not have the look and demeanor of a murderer, since Officer Poole left him in his car, attended only by an unarmed, unsworn citizen, while he went back to pick up the belt and the holster. The judgment of the criminal court of Cook County is reversed. Now, let me tell you why. Let me tell you why. Give me a second. I had to look it up myself because I was like, what the hell? What the hell? What the hell, Leontay? It sounds like murder, right? It does, right? Hold on one second. I'm going to tell you why. I don't want to tell you in all these legal hard words. I want to tell you in plain and simple words, okay? The trial court gave instructions that misstated Illinois self-defense law. So specifically, the way the instructions were framed made it easy for the state to defeat self-defense than the law allowed. So under the state of Illinois, once any evidence of self-defense is introduced into the courts, into trial, the burden shifts to the state to disprove self-defense beyond a reasonable doubt. So it's no longer on the defense to prove that it was self-defense, meaning that the shooter does not have to prove that they act in self-defense. The state have to disprove that they did not act in self-defense, okay? Now, even though it was a crowd of people out there that saw what happened, only 2 people came forward to testify, okay? There were no video footage there. So when the defendant said he was being punched and slapped in the head, the state could not prove that he was not, okay? The state was not able to prove beyond a reasonable doubt that he acted in self-defense, okay? However, the reason why he was convicted and the jury convicted him of it is because they gave the jury the wrong instructions. Instead of them giving them the instructions saying the state must prove beyond a reasonable doubt, they gave them instructions saying that the defendant must prove self-defense. So because the defendant couldn't prove that it was self-defense, they convicted him and gave him 14 years, where it went up to the Superior Court saying that, no, they gave the wrong instructions, and it's up to the state to prove beyond a reasonable doubt that it was not self-defense, and they were not able to prove that. It is very hard to prove something is not self-defense unless it is just point blank deliberate, and most of the time needs video footage. Now, I'm not saying all the time. I'm not saying all the time. They do win cases outside of video footage, but 9 times out of 10, it comes with having like prior notes. You know, they see email, text messages, phone calls, and things of that nature to show that you plotted and planned. Okay. So with this case, People versus McGraw, it was overturned because the jury was given the wrong instructions. It was up to the state of Illinois to prove beyond a reasonable doubt that McGraw did not act in self-defense versus McGraw having to prove that he defended himself. Now, again, it sounds, with all the evidence and everything that came out in court, you would think that, well, I mean, if the guy was no longer hitting him and he ran to the car, retrieved the weapon, and shot him 2 times at first, and then went over to his body and put 4 more into him, you would think that's murder. That's straight up murder, right? But here's the deal. It sounds like it to me. It sounds like it to you. But it's not about what it is. It is about them being able to prove it beyond a reasonable doubt. Now, again, this case is in 1958, but it has been used several times throughout, since it happened or whatever, right? She's at 1950. Wow, didn't know cases went that far back. Interesting. Yes, this case is People versus McGraw, state of Illinois, because they got quite a few of them. So if you guys want to look through that case, you can. But basically, the jury was given the wrong instructions. They were told, hey, you know what? If this guy can't prove that it was self-defense, then he's guilty. So they convicted him on the notion of the defendant was not able to prove that he did it in self-defense. Well, they changed it around, okay? And it is now up to the state to disprove self-defense, okay? And it is a hard thing to do without video evidence. Now, the difference in this and Holly case, and I actually wrote that down, is a couple of differences. One of them, the witnesses, the two witnesses out of a bunch of witnesses that was there, they testified that they saw him shoot the guy, right? They didn't testify that the guy was beating his ass. They testified that they saw him shoot the guy, right? They, put the gun down and shoot him or whatever. So it was a state witness. It was the state's witness. No one came forward on behalf of McGraw, even though as they were out there on the scene, on the prosecution and the defense side, they were saying that, oh, yeah, he was getting hit. But of all those people, only 2 people came to court. Only 2 people were willing to make statements, and only 2 people came to court, okay? So can you say with your entire chest that Holly was correct in killing Miss Meeks? And if she had to shoot multiple times. There is no way she had to shoot Miss Meeks that many times. So are you asking me a question or are you answering it? Because it sounds like you didn't even allow me to answer the question that you asked me before you answered it yourself. So because of that, I'm not entertaining your question, because if you're going to answer it, then you don't need an answer from me. Okay. All right. So again, but it was overturned and he was freed. He was let out, did not serve no time. He's a free man because it is up to the state to prove beyond a reasonable doubt that it was not self-defense. Okay. This guy, oh yeah, let me say this. So the officer was 45 years of age, 6'1", approximately 240 pounds, where McGraw was 5'8", 175 pounds. So the officer was bigger in height. He was taller and bigger in size. Okay. So the officer was basically, from what the defenders, the defendant said, he was hitting him upside the head. He was hitting him and punching him upside the head. He broke away, went and retrieved the weapon, came back and fired 2 times straight up. When his body went back and he laid to the ground, the guy came back and put 4 more bullets into him. And he was able to get off and claim self-defense. But the reason why he was able to get off, not initially, he was found guilty initially, but the reason why he was able to get off, because the jury had the wrong instructions, one, and it is not up to, and the reason why they didn't retry it is because the prosecution said that they didn't have enough evidence to prove beyond a reasonable doubt if it was self-defense or not. They basically said, we don't really have the evidence to prove that it was not to disprove self-defense. There's no video footage. We don't know if he was being hit, this, that, and the other, right? Now, I'm sure things have tightened up since then, because now they say once the person is no longer a threat, and if you continue to shoot, right, that you are wrong. They can get you on something else, but they didn't get him on anything else. This guy said that he got tired of getting hit upside the head and he shot, and said that it was self-defense. So this is a case law. It's very interesting. I would love to hear a lawyer argue this one, and hopefully we will hear it in the Holly case. Apparently, this has come up quite a bit in a lot of self-defense cases in the state of Illinois. So I would just love to hear an attorney argue this. Okay. She says, I'm asking, I read this case. But you can't say you're asking because you responded. You responded to your own question. Okay. So nevertheless, So with that being said, and sorry for the whole incident or whatever. I may have to just go back and delete a good little bit out of this live so it'll flow correctly or whatever. She said, anyone know what the case is about or more is discussing right now? Oh, Kimberly, it is called, like, let me just show you what it is. That way you guys can look this up yourself. Okay. So it is the People versus McGraw of the state of Illinois. Okay, so Livingston McGraw is his name. Livingston McGraw is the guy's name. All right, People versus McGraw. He was initially, this is out of Illinois. He was initially not just charged, but convicted by a jury of first-degree murder. Okay, but because the state gave the wrong jury instructions, or the judge, I guess, I don't know whoever gave the jury instructions. I think it's the judge. But because the jury instructions was for the defendant to prove his innocence, prove that it was self-defense and not the other way around, it went up to Superior Court, right? So it was overturned at Superior Court. The prosecution could have turned around and did another trial. However, the reason why they didn't is because they could not prove it beyond a reasonable doubt. They had no video footage or anything like that. Okay. They had no video footage to show whether or not he was getting hit upside the head or not. Okay. So, but anyway, this case right here shows that in the state of Illinois, one, the victim does not have to have a weapon on him in order for another person to use legal force, especially after he is being hit in the head. This guy was being hit in the head with his fist or whatnot, and he defended himself with the officer's weapon that he ran back to the car to retrieve. Okay. So again, only reason why I'm bringing this up, because a lot of people have the misconceptions that a person is guilty because the other person didn't have a weapon, or a person is guilty because they retrieved a weapon, although that's not what's been said in the Holly Johnson case. Okay, so what the defense is saying in the Holly Johnson case is that she had her weapon on her. She did not go back to the car to retrieve her weapon. All right. So, and in this case as well, the people that was the witnesses, they were in transit. They wasn't there the entire time. The two people that did come forth and testify in court was in transit. Sounds familiar, doesn't it? Sounds familiar, doesn't it? They wasn't there on the scene the entire time. They were driving by and just so happened to see. And one guy said that he only saw the shooting, after the two shots, he saw the guy standing over him and shooting down to the ground at his chest. Okay. So he didn't see the guy being hit across the head. But just because a witness doesn't see someone being attacked, hit across the head, does not mean it did not happen. Okay. You guys are still communicating with Pamela. So anyway, but let me read some of y'all answers. Y'all questions. Okay, this must have been when I was out. Oh yeah, you guys talking about something totally different. Christine, you funny. She said, I see why they big mad. Rent or not, she lived there. Who said I rent? I do rent though. Don't you rent this? Oh yeah, I do. I rent it. I do. So anyway, but do y'all have any questions about this case law? They still running with that. She went back to her car. Well, how are they going to prove that? How are they going to prove that? To be honest with you, The two witnesses that actually said, I think only one actually, witness number 3 is the only one that said that she went back to her car. She was not there the entire time, okay? And she has inconsistencies in her own statement, okay? And where she's going to hurt the state is that the fact that she came out to YouTube on a non-neutral panel, okay? And as a witness, you can't do that. You have to be neutral. You can't, be on the side. You can't, as a witness, you can't just be like, oh, I'm on this side or I'm on that side. So she's actually, in my opinion, is going to hurt the state more than help the state. She said, I'm just waiting on the cross-examination. Well, if you're gonna come in my chat being rude, I'm gonna put you right here to color. There you go. There you go. She said they fail to realize a lot of stuff that the witness said is not going to be able to be proven, only words of mouth, because there is no camera or any cameras to back it up. Exactly. That is absolutely true. Because there is no video footage, and let's go a little further, because I'm not saying it has to be video footage 100%, right? Not saying that all the witnesses can't be considered reliable. Here's the thing. The witness does not override the evidence, the medical evidence, the autopsies, okay? The autopsy report, the medical evidence, the physical evidence, it does not override that. So, and we already know the evidence does not match the witness statement. The witness said, one witness said that she was retreating. She had turned slightly to walk back to her car. Well, the evidence does not show that at all, because if that's the case, she would have been hit in her shoulder or her back or the back of her leg, whereas the autopsy report says that she was hit from the front, which indicate that they were face to face. Face to face. Okay? She said, did the camera show them attacking each other? In this case, no. Are you talking about this? You talking about Holly case or the McGraw case? Which one are you talking about? She said, in California, the laws are different regarding self-defense and using a firearm. Yes, a lot of states are different. A lot of states are absolutely different. A lot of states are absolutely different. But in the state of Illinois, the victim does not have to have a weapon. Again, the victim does not have to have a weapon. Now, that doesn't give you a right to just go and pun someone. You have to, there's other requirements. And still, it's up to the state to disprove that she felt that her life was in imminent danger, to disprove that they're saying that Romeka was the aggressor. And they have to disprove that Romeka was not the aggressor. Good luck with that. They have to disprove that Romeka was not the aggressor, disprove that Holly did not feel that her life was in imminent danger or threat. And they also have to disprove, it's a third one. Let me see. Give me a second. It's 3 of them. Normally, I would know it off the top of my head. What is it? I know it's the aggressor, imminent danger. Oh, yeah, and I think reasonableness. No, hold on. I don't think that's it. Let me see. Hold on. All right, hold on. Let me tell you. So for the state of Illinois, okay, so it says for the state of Illinois, the state must disprove self-defense beyond a reasonable doubt. It says for first degree. Oh, it's 6 counts. I thought it was 3. Okay, so it's for any of the, okay, it says what the state must prove for first degree. For any of the 6 counts, the state must prove all of the following beyond a reasonable doubt. They have to prove that Holly performed the act that caused Romika's death. She did not. Hold on one second. Hey, what's up? Y'all be calling me while I'm on live. What's up? Okay. All right. Okay. Sorry about that, y'all. Okay, so the state must disprove self-defense beyond a reasonable doubt. It says for any of the 6 counts, the state must prove all of the following beyond a reasonable doubt. Holly performed the act that caused Romika's death. She did so with one of the required mental states: intent to kill or do great bodily harm, or knowledge that her acts created a strong probability of death or great bodily harm. And the killing was not justified, legally justified. And that's going to be the big one right there, that the killing was not legally justified. Okay? It says that third element is where self-defense lives. So the third one, and the killing was not legally justified. If they are not able to prove that the killing was not legally justified, then self-defense stand and she is acquitted. Okay? Now it says what the state must prove to disprove self-defense. It says Holly did not reasonably believe deadly force was necessary. They must prove that a reasonable person in Holly's position would not have believed they were in imminent danger or death or great bodily harm. It says this is a huge hurdle because fear is judged from her perspective in the moment, not with hindsight, not with calm reflection, and not with, well, anyway, that don't mean nothing. But it says, if a jury thinks, I can understand why she may have been afraid because of all the death threats, the threats of her child, you pulled up on somebody, rushing toward them, swinging on them, right? So if any one of the juries say, well, I can understand why she may have been afraid, I mean, then the state fails their point. If they say, I can understand why she may have been afraid, given the fact that her grandmother received death threats, she received death threats, her son received death threats, okay? Given the fact of all of that, she had to go and get a no contact restraining order. Given the fact of all of that, if one person said, well, I could see why she may have been afraid, I could see that, then the state loses. The state lose, period. Okay? So then now we all know she would never be acquitted, but we do know that Carlos told the cards. Huh? We do know that Carlos told, I swear y'all didn't graduate from the 5th grade, told the cards if he was the man up and take those assault charges, would he held Romika and he put her in a charge. Child, go back to school. Go back to school and then come back, okay? Go get some education. Go get some education. Basically, even if they could prove that Holly went to the car to get her firearm, it still doesn't negate her self-defense claim. Yeah, but how are they going to prove that? That's the thing. How are they going to prove it? They don't have no camera footage. And she didn't go back to the car and get the weapon. So how are they going to prove it? How are they going to prove something that didn't happen? She did not go back to the car and get her weapon, you guys. Her weapon was on her. That witness just literally just came out and just told a bunch of lies. For the one saying Holly's not getting acquitted, go to law school, you uneducated slow turtle. You said it, not me. If you're gonna come over to my chat and get smart, at least learn how to write. God damn, child. It's too easy. The evidence is not good for the state. It's not. The evidence is not on the state side right now. I'm telling you, it is not on the state side right now. The evidence is not on the state side. I'm telling you, social media The reason why they're doing what they're doing is because they were told one side of the story. These people have not done no research. They are literally just out here. Let me just say this right quick, okay? For those in the back, right now, the trial hasn't even started. And a lot of people have already deemed her to prison. Oh, she's going to prison because if she wasn't, why she's not out right now. Those people clearly do not understand law. They clearly do not understand procedure. They clearly do not understand process. Okay. This is detention hearing. The state of Illinois has a no cash bond. If they had a cash bond, she would probably already be at home. Okay. First degree, they don't just let you out just like that. It takes several times in order for them to be released. And most of the time, it takes the appellate court to get involved. Okay. We know that. Why? Because we did the research to find out. There is over 140 people right now in the state of Illinois that has been charged with first-degree murder that is at home on home confinement fighting their case. It took them 2 to 3 times in order for them to be able to be released, okay? So for the people that's saying if she was innocent, she would be at home right now, do not understand nothing about court or law or research or understanding or any of it. Literally should probably just give up doing law cases because they do not do the research that is necessary to properly understand the process. Okay. Now, with that being said, it is at the appellate court now. All right. Now, to be honest with you, I don't know if they'll win in the appellate court or not. I don't know. But what I do know is Holly has a strong, and I'm going to say it again, a strong self-defense case. Again, Holly has a strong self-defense case. Okay? Now, I know a lot of people don't want to believe and don't want to look at Romika other than just in pink attire. But just because a mother that wears pink, or pink was her favorite color, and she wrote a nice letter to her son and put it in his lunchbox, does not negate the fact that she was an aggressor on September the 8th. She was the aggressor per the defense, okay? Per the defense, she was the aggressor. It is the state responsibility to prove that she was not, that Holly was not, okay? Excuse me, that Romika was not. It is up to the state to prove that Romika was not the aggressor, that Romika did not rush Holly, that Romika did not swing on Holly. Now, with the witnesses being there, neither one of them, out of every single witness that the state has brought forth so far, besides Carlos, number 2, 3, 4, and 5, neither one of them were there the entire time. Their vantage points was limited, okay? And they will be challenged, and neither one of them have been cross-examined, okay? So for people to really think that the state have this in the bag, I'm here to tell you, baby, it's not that easy. You're going to have to do your homework. You're going to have to do some research to find out that this is not an easy case for the state. Just because she's locked up now does not make this an easy case for the state, okay? She said, without due respect. Without due respect? Do you mean without due respect? I will having some difficulty because I dropped my phone and the dishwasher, but I'm not stole no type of way. Are we going to talk about the white Penske work van? Are you in the right chat? This is about the Holly and Romika case. Okay? I think that you might be in the wrong chat. I don't know what about no Penske work van and the dishwasher and the phone and the, I think you might be in the wrong chat. Nothing is worth a life, and this is painful reminder of that reality. Well, when it comes down to your life or your child's life, I'm sure you would feel differently. And Pamela, I'm just gonna say this to you, baby girl. You know, I just pray that your life or one of your kids' life is not in jeopardy, and you guys are forced to defend yourself, okay? Because you guys are convicting a young lady before she's even found guilty. This is America. I don't know where you guys are dialing in from, but this is America. You are innocent before proven guilty. But a lot of you guys have already deemed Holly Johnson guilty, all because, well, one, you have no idea what really happened, but two, because of a 21-year-old Hispanic person came out on the internet, on YouTube, and falsified her statement. I ain't even gonna say falsified her statement, but falsified a statement because she told some untruths. One of the things she said was that she was there and saw the whole thing. That's just not true. She was not there the entire time. She was actually there a very, very short period of the time. She's still on camera. She was not there the entire time. She was on a bus. She was riding away from the scene. So I'm just here to tell you guys, it's not going to be what you think. It's not going to be as easy as you think. Not with the evidence they have right now. She says, I'm not convicting her. Absolutely not. And yes, I have 6 grown daughters, and believe me, I have seen a lot. Well, I hope that if it ever happens in your life where one of your daughters have to defend themselves, I hope that, you know, the world don't just shit on them the way you guys are shitting on Holly. Holly was minding her business that morning. She was minding her business that morning when Romika pulled up on them and wanted to fight Holly. I don't care what anybody says. I believe that with my whole heart, that she went to fight Holly. All right, this ex-pastor says, why are you telling these lies? In Illinois, all the state must prove is that Holly knew she would cause great bodily harm or death to Romika Blackman. This is all that must be proven by the state. You are incorrect. You are absolutely incorrect, okay? You are absolutely incorrect. The state must prove, or should I say disprove, that it was self-defense. Now, however you want to slice it or dice it, I'm going to need you to go look it up, okay? Now, if you come to my chat talking about some lies, I'm going to need you to bring some facts, and I'll drop the link for you to come up with your facts, okay? Come up with your facts. I'm dropping the link, so come up with your facts. Don't come up here saying things that you think. Come up here with your facts. That is not all the state must prove. They must disprove. They must disprove self-defense. Okay? Now, go back and read it again. Go back and read it again. Okay? Talking about only thing they got to prove is that she knew she would cause great bodily harm. Okay, you don't even sound like you. Okay. If that was the case, then they wouldn't even have a trial. If that was the case, they wouldn't even need a trial at all. And that every single person that has ever shot someone, no one would be able to say self-defense. Nobody. All the state must prove is that Holly knew she would cause great bodily harm. Let me ask you something, ex-poser. If that's the case, I got a question for you. If that is the case, then why didn't the 14-year-old that ran to the car, got a weapon, came into the restaurant, shot the guy that was shooting his mother, that was hitting his mom, then why did he get off? He shot a guy, and then he went outside after the guy ran out of the store, and he shot him some more. So why did he get off on self-defense? I don't know if you were she or he, sir or ma'am. If that's the case, if the state must prove that they knew shooting someone would cause great bodily harm or death, then why did that person get off? Why? Because it takes more than that. Because you came over here with half-truths. You came over here with half-truths. You came over here thinking that you knew what you were talking about, and you did not. Okay? This person said you need to get your law degree because, okay. All right, so do I have somebody up here?
Yeah, you do.
Okay, let's go.
Where are we going?
Excuse me? You came up here. It has to be a reason you're up here, right?
Absolutely. And so you quoted that the state has to prove these things, and
yes, the state has to disprove self-defense beyond a reasonable doubt.
No.
Yes, they do. Why? Let me ask you something. Why wouldn't the state? Okay, so why wouldn't the state have to disprove self-defense beyond a reasonable doubt?
Disprove self-defense beyond a reasonable doubt? What are you saying? What are you even saying? Disprove self-defense? The only thing that the state has to prove in first-degree murder is that the individual involved, okay, the defendant, intended to cause great bodily harm or death to the
That's not true.
individual.
That's not true.
Law is 7.
That's not true. They have to. How do you in a self? Okay, so let me ask you something. If self-defense is raised, then what?
That is Holly's that's her defense. She's saying that she didn't commit first-degree murder.
And they have to disprove self-defense. If she's saying it's self-defense, they have to disprove it.
Did you ask me?
What part of that do you not understand?
I don't understand why you're not going according to the law, and you're going off of you sound very emotional. I'm telling you the law is 720 ILCS 59-1. If you would like to take a moment and look it up, I will.
Okay, 720.
I'll put it in the private chat for you, love.
No. You could just say it. I can hear. I can hear.
720 ILC 59-1A.
That's the first-degree murder statute. But I'm going to need you to look up the self-defense one. The statute for self-defense.
She's not charged with, oh my gosh, honey. She's not charged with self-defense. She's charged with first-degree murder.
She's charged with first-degree murder. But so as a defendant, listen. As a defendant, even though she's charged with first degree, her defense is self-defense. And the state of Illinois allows a self-defense plea. So if she's saying it's self-defense, you don't think that the state of Illinois have a self-defense statute?
She is not charged with self-defense.
That's her claim. She's claiming self-defense. So I'm asking you this. When a person claims self-defense, what do you think? Do you think that there is a law for self-defense?
There are laws that support self-defense.
Okay, let's go over those because that is her claim that it was self-defense. So
I
why wouldn't they entertain it?
I'm not here refuting her claim. We all know that she pled self-defense.
Which means what?
Arraigned.
Which means that the state has to disprove
Here,
it.
no, I'm here
What are
saying what the state must prove in court to
But
have
so Trina, if a state,
agree.
if a self-defense claim is raised in court, can you do me a favor? Since I just looked up what you just did, right? Can you look up if a self-defense is raised in court, then what does the state have to prove? Can you look that up for me, please?
The state has to prove that she intended to cause great bodily harm or death.
No, listen to what I'm saying. Okay. So I'm gonna look up, and I'm gonna look up what you wouldn't look up. Okay.
When trials start,
I'm gonna look up what you didn't look up. Okay.
Well, it don't matter what you look up. That's her defense, and the state make it make sense. Why does the state have to prove Holly's defense?
They have to disprove self-defense. They have to. The burden of proof is on the state.
They don't have to disprove her claim. They're disproving.
Yes, they do.
They're disproving her claim.
The burden of proof is on the state to prove its case. Okay, so let me say it like this: the state is bringing charges against her. Okay.
And what are those charges?
The charges is first-degree murder, and she's saying I didn't commit first-degree murder. It was self-defense.
Okay.
So they have to disprove that it was not self-defense.
They do not. They accused her.
Oh my God! What are you kidding me?
They accused.
Okay,
her.
listen.
I
can't believe you were saying this.
Would you listen and would you give me like 1 full minute? That's it.
Okay, go ahead.
They do not have to prove it in that manner. All they have to prove is what they charged her with. They cannot deviate from her charges. No one's been charged with self-defense. In Illinois, first-degree murder, you must prove that Quadasia intended to cause great bodily harm or death to Romika. And I say it's an easy thing to prove because anytime you shoot someone, you're expecting a result of at least great bodily harm. When you shoot someone twice in the face and in the femur, 2 major arteries, because in the face, it adjoins to your carotid artery. The femur is your femoral artery. She was going to bleed out. Okay, those are fatal wounds. If you go to a range, they'll rate that as a great shot. Okay, she's intending to cause great bodily harm or death. Now, why she was intending to do that is her self-defense claim. She's claiming she needed to defend herself, or great bodily harm or death would have been done to her. What am I saying that's incorrect?
So if she's saying that it was self-defense, then the state has to prove that it was not self-defense.
And they're going to prove
beyond a reasonable doubt.
Yes, and they're going to have to prove that by saying and showing that she, which is Quadasia Johnson, intended to cause great bodily harm or death to Romika, and she was not in defense of herself.
You do know it's more than that, correct? You do know it's more than that, correct?
As far as what? Different circumstances that took place?
So the self-defense part is they have to prove that it was not justified. She's saying that it was a justified homicide, okay? Which is self-defense. They have to prove that it was not justified. It was not justified, okay? Meaning that it consists of different elements than just she intended to cause great bodily harm, okay? State of mind is also one of them. Did you know that? State of mind What state of mind was she in? Was she in reasonable fear of her life? Was she in
No.
intimate danger? If she believed that she was in intimate danger, okay, then it is justified. The girl ran up on her and swung at her.
And so, Amore, is people who get swung on every day.
Yeah,
Every
but
day.
that may be true. However, people that get swung on every day are.
And
Wait a minute, hold on, because see, I let you talk, so now you're gonna let me talk.
I sure am.
Okay, so this Romika sent multitude of death threats to this young lady and her family, with that will be proven in court. Okay, Holly took the extra step to go get a protective order against this lady, a no contact order against Romika. Romika violated that and still chose to pull up on her. And even after things had calmed down, after Carlos was able to calm things down for a moment, she jumped out of the car and rushed this lady and swung on her. She had her baby in the car. So she has every right to defend herself in the state of Illinois. Per the state of Illinois, she has a right. Let me read it. In Illinois, self-defense allows the use of force, including deadly force, when reasonable necessary to prevent imminent death, great bodily harm, or a forcible felony. The state requires a duty to retreat in public if safe, but not in homes. Castro doctrine. Legal tools include license, concealed, pepper spray. Okay, it said all that. Anyway, so key aspects of Illinois self-defense law: reasonable belief and proportionality. Okay, the force used must be proportionate to the threat. A reasonable person standard applies, meaning a jury will determine if an average person would act the same way given the circumstances. Okay, meaning it wasn't just two women out there arguing and one swung on another one. We're talking about a woman that had been stalked, had been harassed, had been threatened for damn near a year. Her child had been threatened. We're talking about a woman that went and took out legal papers on her stalker. We're talking about a woman that was minding her own damn business after enjoying a weekend with her son's father and was ambushed by her stalker. We're talking about a woman that when the stalker jumped out the car, said, I told y'all I was going to catch y'all together, whatever, right? And then wanted to fight her, but the boyfriend got in the way and would not allow that to happen, right? Restrained her to a certain extent and was able to talk her into getting back into her vehicle. She got back in her vehicle and then got out of her vehicle and rushed toward this young lady, swung on her, grabbing her hair and restricting her head while her son was in the back seat of the car. And this is the same young lady that said, when I see you, I'm going to beat your head in. And I'm going to bust your head wide open, amongst other shit. So that is self-defense per Illinois law.
And so, can I address everything that you just spoke about?
Of course.
Okay, thank you so much. And so you said, that there were multiple threats by Romika to Quadasia Johnson. Those were all verbal threats. Quadasia Johnson.
It wasn't all verbal. There was some written ones as well.
Okay, so they were written and they were verbal. My point is that they were.
How else would they be if they're not written and verbal? I mean,
they would be
sign language or something.
They would be in person. They would be on the pull-up.
This was her first time ever seeing her in person, like face to face.
Okay, and so if she's so why is she so worried about verbal threats and text threats if this is the first time, right, that she's seen her on September 8th? Like, why would she be so worried?
Because when you think if somebody if somebody threatened your life and your child life, when you think that they are coming to carry out what they said they was going to do,
I need to see proof of that.
You will. I promise you, you will. I promise you, Trina, you will. You will. Especially if you go into court. You will. Not only will you see not only will you see the written, you will hear voice notes where she threatened her life and to bust her head wide open when she sees her.
Okay. And you know, that's what she put in her petition. That she was gonna, you know, that I have the petition. Okay. But here's the thing about that.
Okay, go ahead.
You know, again, that's verbal, you know, be it voicemail or however, in text. She was not threatened face to face. And I saw video.
She did, Trina. Okay, and when someone run up to you and if somebody run up to you and swap you across the face, what is that? What are they doing? Is that a love tap?
You're talking about on September 8th. I'm talking about
You never saw her before. So how was she? This is the first time you ever seen someone that said that they're gonna kill you. So you supposed to just take that lightly?
No, Amora, because I did not know until I saw your video when you were showing Romika with the, you know, the
scissors in her hand.
Yeah. And she had on like the black shirt and the Burberry shirt or whatever. She was saying to Carlos, you know, you said you were blocked in. Why you lie?
Yeah, I got that.
When you showed that video, you said that there's Holly's car right there.
Yeah, that was Holly's car, but Holly was upstairs, never came down. Never came downstairs.
Never came down.
Right. So if she wanted to kill Romika, why she didn't come down that day?
Oh, no. It's not about if she wanted to kill Romika. Why?
I thought y'all was calling her cold-blooded murderer, that she was jealous and wanted to kill Romika.
I will get into that part.
You know, there's another part of the video that hasn't been released.
Because why? Because
do you know there's another part of the video that haven't been released, that she actually called 911 on Carlos that day, and right in his face while he's videotaping her, said he just beat me down in the alley. He beat my face in, and he got weapons. He got a whole bunch of weapons. He got weapon charges too. And he beat me down in the alley. Do you know that? You don't know that because you haven't seen the video. She literally sat there and told a bold-faced ass lie on him, trying to get him locked up, and told him right before she called 911, said, I'm going to call and have them come pick you up right now. And literally called 911 while looking at this man, while this man got the camera on her, and said, I'm going to call and have you arrested. And literally right there said, he beat me up, he beat me in the alley, he beat me down. All this while he's videotaping her lie. And then when she got off the phone with the cops, you know what she said? She said, they're going to come and arrest your ass, and it's the weekend, so you're going to have to stay over the weekend too, right? They're going to come get you. You're going to have to stay over the weekend. And then she was like, and that's why I fucked your friend. It was good too. And I fucked him 7 or 8 times, and it was good. Nah, nigga, what?
Okay, but let's say that's true.
But that's y'all princess, though. But go ahead. Go ahead.
Any proof of that? But let's say that's true.
What
does that have to do with her and Quadelia?
Character. If somebody's willing to lie to the police just like that when they're being videotaped, that's character. That's character. What does that say about her? So, what if Holly would have done that? If Holly would have called the police right then and there.
That has to do with Holly's self-defense claim. Romika's
because Romika was mad because Carlos was moving on with another woman. Moving on with another woman. He was mad. Do you know that she got dropped off at his house that day by a Uber driver because he told her he couldn't come and pick up the baby? She got dropped off, and he's like, "No, you can't come in." She wanted to come in so bad. He was like, "No, you're not getting in. You're not getting in." And do you know that's the same day she busted his shit up? Man, y'all just.
Has she ever bust Holly shit up?
No, because you know what? And to be honest with you, do you know she didn't even know that was Holly Carr right there? She just assumed he was with another woman. She didn't know that was Holly Carr.
How did she know it was Holly's car September the 8th?
Because she saw them. She saw them. When she jumped out the car, she said, "I told y'all I was going to catch y'all together," or some shit like that. "I told y'all I was going to catch y'all." She saw them.
Okay.
She saw them. And see, what you don't know, Trina, is they talked that morning, okay? Carlos and Romika talked that morning. She wanted him to drop the baby off because she was running late for work. He says no, he had something else to do. And just a woman's intuition, she already knew something was up. She saw just the day prior that Holly was at the mall getting the baby ears done. So she knew something was up.
Is that what he told you? Did he show and prove to you?
He got text messages of them going back and forth that morning. Yes.
Oh, okay.
Yes.
And so why would he be out when she's out?
Well, what are you talking about? What do you mean why he's out because she's out? Who say he can't be out? He was walking his baby's mama to her vehicle so he can go to the gym. And mind you, Romika dropped Lil Los off and rode around for 4 whole minutes before busting the U-turn. So answer me this. What was she doing for 4 whole minutes?
She dropped him off or his lunch off?
She dropped the son off.
Then why did she drop the lunch off later?
Well, okay, well, whatever. As she was driving, she's on camera leaving the parking lot. I don't know what happened. I don't know who she dropped off, to be honest with you. But as she was leaving the school parking lot, she left the school parking lot and she did not bust a U-turn until 4 minutes later. Did you know that?
I don't have any evidence of that.
Well, but did you hear the defense attorney said in court that it was on camera?
She said a lot of things, and a lot of things she said refutes what she's asking for and requesting for her client. And I'm not understanding that, except that it's a bunch of, BS.
What are you talking about? So you think that the defense attorney will lie to the judge and say that it's on videotape of her for 4 whole minutes after leaving the school, for 4 whole minutes before she bust a U-turn? You think the defense attorney will lie to the courts?
I didn't see that.
Because wouldn't they want to see it?
I wasn't there for the hearing. I did not see that in any of
I'm sure you read it in the paperwork. I'm sure you read it in the paperwork.
The paperwork was Ari trying to refute the timestamp of Shark's camera. Everything else was on.
But that was 2 courts ago. That was 2 court hearings ago, right? So they already got that wrong. She knows that the timestamps was incorrect now. But I'm talking about the camera, the pod camera for the police pod. It caught her busting the U-turn.
No, the Shark's camera caught her busting the U-turn.
No, that's not what I was told. That's not what I was told.
I don't know what you were told, but I'm just talking about Ari's paperwork. If you want to see it, I'll give it to you.
Like I said, so what camera caught her leaving the school? The Sharks camera? Because the Sharks can't see the school parking lot. I hope you do know that. It was the pod camera. It was the pod camera that caught it.
I heard no mention of the 4 minutes driving around in a parking lot.
I promise you, it's 4 minutes. I don't know why you haven't heard it, but it's 4 minutes.
I don't care what I hear unless I'm in the courtroom. I don't care what people say.
No, this came from the courtroom. I don't go over there and listen to any of y'all. This came from the court.
I can only go by the transcripts from the court and what Ari's motions were saying, and it had no mention of Romika driving around at the school parking lot.
Okay, you guys in the chat, have y'all heard anybody say anything other than myself say anything about the 4 minutes that she rode around, or she actually didn't say she rode around, it said she rode on some street or whatever. Did anybody hear about the 4-minute gap in her dropping the son off into busting a U-turn? Did anybody else hear that? Because Trina hasn't heard that. Just like she didn't know that she was, threatening her life and all that good stuff. And she didn't know that her and Los actually spoke that morning.
Well, let me ask you this.
Actually, you know who said it also? Tia Urings. She said it as well. Do you listen to her?
Oh, I can definitely contact Tia.
Okay, so she said it on not this last one, but the one before that.
But
let me ask you something, Trina. I just want to ask you something from adult to adult. If a woman has jumped in your inbox, your social media inbox, then left messages, voice notes, telling you, making threats for what she's gonna do to you. If she has sent you messages on your phone to the point where you actually had to get your phone number changed, okay? And she's also, hold on. All right, I got it. All right, I get to read it to you. Hold on 1 second. All right, so I got it for you, Trina. Okay, since you didn't get that one, okay? Let's read what it says. I know you're real good at the paperwork, right? All right, so right here it says 4 minutes after dropping her son off. Hold on, did my mouse just go out? Okay, 4 minutes after dropping her son off and exiting the school building. Oh, damn, they got her exiting the school building at 8:57 a.m. A white Kia sedan driving eastbound on Cermak is captured on camera making a U-turn facing westbound onto Cermak. See Exhibit 4, Sharks External Street Camera. Okay, so it was Sharks External Street Camera. Victim owned a white Kia sedan and used it to drop her son off at school on 55 West Cermak, the son whom she shared in common with Smith. So you didn't see this in what you...
Where does it say 4 minutes she was driving on State Street or anything? It says 4 minutes after dropping her son off
and exiting the school building.
She's seen driving eastbound on Cermak, and
it's captured doing what? And captured doing what?
Making a U-turn. So
okay, and when she made that U-turn,
show me where she's driving around for 4 minutes, girl.
No, I asked you, where was she for those 4 minutes? We're just assuming she was driving around. So I asked you, where was she after she left the parking lot? Where was she? And right here it says 4 minutes after dropping her son off and exiting the school building, a white Kia sedan driving eastbound on Cermak is captured on camera making a U-turn. So 4 minutes after leaving the damn school. So where did she go? What was she doing?
She must have just been leaving the school. Maybe that's the time it takes for her to leave the school and go to her car, and then that's the next time it catches her on camera, 4 minutes later, as she's on the street with a camera.
Yeah, okay. So first you didn't hear about it, and now you're trying to justify it.
I'm saying it still does not say 4 minutes she drove around. Where does it say that?
Actually, I think it does say that or whatever. Or she related in court. She said something about she passed one area and then came. Well, right here it says it should be noted that when the video from Sharks was sent, there was a label stating that the video was 35 minutes offset. So although the video shows Smith exiting the alley at the 8:21 a.m. mark, that is incorrect. 8:56 a.m. is the time Smith exited the alley. Similar, the video from Sharks capturing the victim making a U-turn on Cermak was sent with a label starting the video was 35 minutes offset. So although the video starts at 8:22, the correct time of the U-turn was 8:57 a.m.
Did she have an expert look at that video and refute the timestamp of the video?
Well, I mean, don't you think that's for the courts to figure out right there? All I'm asking you is 4 minutes after she left the school, she busted a U-turn. So anyway, all I was saying, only reason why I even said that is because the only reason why I even said that is because
was Carlos and Holly on the scene on Cermak first or Romika?
I don't know who was first. All I know is they were minding their business. He drove Holly to her vehicle. They were minding their business and she pulled up.
Okay.
And the CTA bus does show that she was parked closer to Carlos. And from right now, that's the only footage that shows that.
Because they weren't minding their business and you got the better part. And you can't shoot someone because they swung on you. And your baby daddy just remembered that they swung on you 2 hours after the fact. That's something he should have stated to the police, and he should have stated to the police.
He stated to the police and to multiple people out there on the scene that it was self-defense. He told them that it was self-defense.
And he stated to the police that Romika swung on Holly.
Yes, he did.
2 hours later, according to the police body cam footage.
He said that it was self-defense, that they were ambushed, and it was self-defense.
Is swinging on someone actually hitting someone?
Yes, because she didn't just swing on her. She grabbed her hair, so that's taking control of someone's neck.
Why didn't Carlos say she grabbed her hair?
He did. Trust me, it's in his statement.
In what statement?
His statement that he gave to the officer.
Okay.
Okay.
I'm not trying.
But nevertheless, guess what though? Guess what the beauty of this is though, Trina? And this is law. This is not even more. This is law, right? The beauty of that is if Holly out her own mouth tells her attorney, which obviously she did because the attorney said it, that Romika swung on her and grabbed her by her hair, it is up to the state to prove that that did not happen.
Okay, why hasn't her attorney stated that in any of her motions?
She did. She did say that she was hit.
She talked about her being swung on, and I told you that's a statement made by Carlos 2 hours after the fact. However, why is there no mention of her hair being grabbed or pulled?
Well, first of all, the trial hasn't started, okay? The trial has not started.
Hard to mention the swing. Why wouldn't she mention her hair being pulled? Don't you think that
the trial hasn't started? I'm sure there's a whole lot of other stuff that hasn't been mentioned as well. And a whole lot of other things haven't been mentioned as well. It's going to be. You guys are trying to get everything out right now, and I'm telling you, you're going to be in for a rude awakening, especially when you see all these nasty, disgusting text messages that Romika made these threats to Holly.
People talk shit all the time.
Also, so let me ask you something. So if I tell you, and then not just one time, several times, if I tell you when I see you, it's on site. When I see you, I'm gonna bust your head open to the white meat. When I see you, I'm gonna kill you. When I see you, I'm gonna spit in your son's face, right?
That line, as it pertains to me in specific, is like 7-8 motherfucking miles long. Are you serious? As much shit as I talk, are you serious?
Okay, well, Holly is she don't talk shit like that, okay? So, she took it serious.
Video.
She took it serious.
She do videos, right? And don't even create content, but she do videos for the other baby mama talking about what she never ever would do.
But I would never is not making a threat. It's not making a deadly threat. It's two different things. I would never is not making a deadly threat.
That is true. That is true.
And then the fact that she never said her name, that's not even it's not even gonna be admissible in court because she never even said her name.
Everybody knows who she's talking about.
It doesn't matter what everybody knows. She did not reference her name. It will not hit court.
This is not the world of YouTube. She made specific inferences to Romika's.
But that's not death threats. That's not death threats. That's not 19 threats on your life.
I'm not saying it is, and I agree with you that it is different from a threat.
And let me ask you this: if Romika,
if you're not going to agree with the fact that she made specific inferences to Romika with her job, her vehicle, her not having a ride to her birthday party, Romika's wanting to call Carlos and ask about her as the other.
And that justifies death threats?
I'm not saying she did.
She harassed this young lady. She harassed this young lady. This young lady blocked her on her personal phone, and she found a way to jump into her social media accounts.
And so they blocked each other. And not only that, but you mentioned, as well as her attorney, how Quadesia went to the courts for an order of protection. When she went to court for an order of protection on December the 4th of 2024, they denied her.
Do you want to know why? Because it was an ex parte. Do you know how to get an ex parte? In order to get an ex parte, physical conduct have to already have happened.
Girl, we are talking about a civil order of protection.
It doesn't matter. The courts do not grant, they do not do emergency orders unless it's an emergency. That ex parte is an emergency protection order. That's why she was assigned a court date, a hearing date. They didn't just throw it out. They just denied the emergency order. But she was granted the default. She was granted by default the 2-year order.
And so they let her do a publication back in March.
Because Romika family allowed her to get evicted and she was staying in a hotel.
I'm not speaking about that. That's what the publication is for.
Okay, so
when the sheriff cannot get in touch with the person, and the publication can stand as contact.
What does that have to do with anything?
I'm stating that they did not give her an order of protection until July.
Right, because they didn't go to court until June.
She's been in there asking, doing publications because they had no contact with Romika and all of that since December. 7 months, and they only gave it to her by default, and it was not active because Romika had not been.
It was absolutely active, and you're going to find out in court how active it really was. Okay.
You're going to find out that.
All right, Trina, we already went there. I'm telling you, you're going to find out in court, but I'm sure you're not going to come back and say, "Oh, damn, I didn't know. I didn't know." Well, I'm trying to tell you. So we just going to agree to disagree on that one. We just going to agree to disagree on that one.
Amor, you want to make the phone call again?
We're going to agree to disagree on that one. See, what we're not going to do is play out the damn whole trial before it even starts. It has to start. You guys have to wait for other evidence to come out. And trust me, they are coming. The evidence is coming.
I'm only speaking on what you're talking about.
And Tammy said the judge already confirmed that it was active. Boom.
Tammy,
Boom.
please sit down. That's why your niece is locked up.
Come on, Trina. You've been doing good. Let's stay here. Stay here. Stay here. Don't do that. Just stay here.
She does
Stay here. Stay here.
the order.
But we're gonna agree to disagree on that order. I say it's active. You say it's not. We just gonna have to find out in court.
Absolutely not, unless served upon the respondent and the courts.
Okay. Okay. All right. Well, why is the judge allowing it then? Why is the judge allowing it as evidence?
Amora, the court is open right now. We can call the exact same court that she went to, which is the Cook County Court in Skokie, and ask them.
Oh, hold on. Let me read this. This says, on the day of the incident, footage, hold on, let me move this out of the way. On the day of the incident, footage captured from the entrance of the National Teachers Academy. Okay, footage captured from the entrance academy showed the victim heading inside the school building with the son. Oh, she was dropping her son off. So it showed her heading inside the school building with the son she shared with Smith at approximately 8:51 a.m. Exhibit Exit 2 school footage. Oh, the school had a camera. The victim was then seen exiting the school building at 8:53. At approximately 8:56, Smith's black Mercedes-Benz SUV was captured coming from an alleyway, turned left onto State Street, and turned right onto Cermak. Smith's Mercedes was double parked 2 car lengths in front of Miss Johnson's vehicle, facing westbound on Cermak. In moving her child from the rear seat of Smith's SUV, Miss Johnson placed her son in the back seat of her black Chevy sedan. 4 minutes, and then that's when it goes into 4 minutes after dropping her son off and exiting the school building. That's when the white Kia sedan driving eastbound on Cermak is captured making a U-turn. So the school camera, let's go back to the school camera is what was seeing her exiting the school building.
Thank you so much, Amora, and I don't mean to interrupt, but before you move any further, you see it says at 8:56, Carlos Smith's SUV is coming from the alleyway, and then it says that Romika is captured doing a U-turn at 8:57.
And that's why they straighten it up right here. It should be noted that when the video from Sharks was sent, there was a label stating that the video was 35 minutes offset. So although the video shows Smith exiting the alley at 8:21, that is incorrect. 8:56 is the time Smith exited the alley. Similar, the video shows Sharks capturing the video making a U-turn on Cermak was sent with the label starting stay in the video was 35 minutes offset. Hold on. So although the video stated 8:22, that's why she got dinged in court though, right?
Pause. Hold on. I almost called you Romika. That means
no, I don't threaten people.
Look at footnote number 2. Okay, it says that even if we could go to footnote number 1. The footnote number 1 say Sharks camera is off. This is Ari's statement to the court that Sharks camera is off. That is 8:21, right? And 8:22 respectively. When Carlos is leaving, it's 8:21. And they saying when Romika do the U-turn, it's 8:22. This is how I know Ari a whole gaslight and liar. Because what time
why is Ari a liar?
Because what time?
Because she's defending Holly?
She lying, Sharks camera lying, or we ain't supposed
everybody lying but Romika supporters.
I'm trying to tell you why she a liar.
But everybody lying but Romika supporters. So Ari lying, Sharks lying. Is the CTA bus lying too?
Amora, you know where this is going. What time do the school cameras got Romika on cam, honey? What did it just say that you just read? That
8:53.
8:53. So
Uh-huh.
is the school cameras ain't wrong. She ain't said nothing about the school camera being wrong.
Okay.
So how is Shark's camera wrong and Romika and Carlos they're left out, right? And then this incident is occurring at 8:21, okay, or 8:30, right?
But it says that's what the camera says. It says that's incorrect. And it says the time is actually 8:56. And this one says 8:57. What are you talking about? She corrected it right here. She says, even though it was sent and blah, 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 it was 35 minutes offset. So although the video starts at 8:22, the correct time of the U-turn is 8:57. Did you not see that?
So what does she mean?
What she mean is, even though it says it was 8:22, the correct time is 8:57. So, which means Carlos came out of the alleyway at 8:56. Romika bust that U-turn at 8:57, a minute later.
So Carlos was there first.
Yeah. And Romika pulled up behind him. So for 4 minutes of leaving the school, maybe she waited till she saw him come out of the alleyway. I don't know because I'm not there.
Ari timeline and trying to refute Shark's camera ain't gonna work. Maybe Romika made that U-turn or whatever in her initial drop off with little Carlos, and then she returned back, we know, to drop off his lunch. Because that's what she say she was back.
Well, but it doesn't show that up here. It says when she exited, when you say drop off his lunch, so you mean went back home and got it and came back and got the lunch? How far does she live?
Went back home or whatever. Because I mean, she
can go back home in 4 minutes. She can go back and come back in 4 minutes.
You can buy that from the local store.
Well, but I don't think she did that because then she put something. But anyway, nevertheless, it says the school camera. So you just said the school camera wasn't off, right? But it said the school camera saw her exiting the school building at 8:53 a.m. in the morning.
The school saw her going in with her son at 8:51. If he forgot his lunch, and she wrote him that note, and she was like, you know how he is or whatever. And
she went in at 8:51 and came out 2 minutes later. I know you're not going to say that she went in and came out, drove home, fixed a sandwich, and came back and went back in and gave it to him. And then 2 minutes later came out again. I know you're not saying that, right?
Or did she drop him and the lunch off?
She lied about the lunch. Bull crap. Okay. She dropped him and the lunch off at 8:51.
Okay.
And the school camera saw her exiting the school building at 8:53.
Okay.
And then she pulled up, or should I say bust a U-turn at 8:57. So that means, was she watching him? Would you assume that?
Was she watching Carlos?
Yeah, because Carlos came out of the alleyway at 8:56. And at 8:57, she bust that U-turn. So was she waiting for him or what?
How could he miss her? If the camera...
Did you say how could he miss her?
If the camera got him at 8:56, right? And the camera got at the school got her exiting the building at 8:53, right? She still got to get to her car. Which is parked right in front of the building. Yeah. So how does she have time to be looking for him? They basically...
Well, for 4 minutes she did. Okay, so what did she do for 4 minutes?
I would say shit at 8:53. How long do it take you to get to your car? 2 minutes most.
No, let me show you. Let me show you. I'm gonna show you how long it takes you to get to your
The
car.
school building at 8:53. She still
No,
got.
I'm gonna show you how long it takes. Give me a second. Let's look at it right now. We're gonna do this. We're gonna see how long it takes to get to your car.
I know from what's written that at 8:56, Carlos driving, and at 8:53, she exiting the building. So we talking about a matter of 3 minutes.
Hold on, because we're gonna see how long it takes.
Camera again. What could she have possibly done in 3 minutes, Amora?
We about to see. 4 minutes, not 3.
What did you do in 4 minutes?
I have sex, bust a nut. I mean, a lot. But hold on.
You had sex with me in 4 minutes, motherfucker. Don't come back. The fuck? Don't bring your ass back, and I mean that shit. Don't come.
What's the name of the street? What's the school address? 55 and what?
Cermak.
Okay, hold on.
National Teacher Academy.
So this is the National Teacher Academy, right? So from what they told me, the parents park right here, right? They vehicles right here on this road as they drop their child off at school. They park on this road. They walk, and they told me
that's the east side.
They said you go in here, boom, boom, boom. You go up to the school and you drop your child off. So are you saying how long it take to go up here, drop your child off, and come back?
Yeah, that take about 3 minutes, 4 minutes to get back to your car. It would take me. I don't know how fast,
Oh, come on. It don't take no damn 3 or 4 minutes to walk through this pathway. Because she left the building at 8:53. So you saying if she left the front door, that's what I say, the front entrance door, car, exiting the school building at 8:53. So if she exited the school building at 8:53, and if her car is parked in one of these, are you saying it's going to take her 4 minutes to get to her car?
Was her car parked on Cermak, or was her car parked in the school parking lot?
Now, the people from Illinois that live there say that people park their car here to drop their child off. They said they parked their car on this road.
Where was she parked?
Huh?
Where was Romika parked?
I don't know where Romika was parked. That's what I'm saying. People say they park out here on this street.
I'm guessing that she was parked right there because that would constitute a U-turn. Because if she parked in the school parking lot and came from right there where the train station is, that would be a legal turn.
Now, and I don't know this, but someone, I don't know, it was David or what. They said if she was going to work, she would have made this right. But instead, she jumped in this lane.
Not a U-turn. So she had to be on Cermak, and that would be a U-turn because she only supposed to turn on State. She's not supposed to turn back around on Cermak going west.
Well, she bust this U-turn right here.
That's the U-turn, correct.
So the school is all the way down here. And she came, she sat in her car, did whatever she did, ride. They said she rode. And something I read, it said that she rode. I would need that other piece or whatever. But she left the school. She dropped her son off, left the school. Okay. That might be her car right there. Who knows? So anyway, she came down here. She jumped in this lane right here. She, in my opinion, she had to see them because look, well, I don't know. It's probably early in the morning. I don't know about the cars. And she bust this U-turn and she pulled up behind him, pulled up behind his vehicle. So I'm going to assume that she saw them from her vehicle, which means that she pulled up with a purpose. It wasn't no coincidental. She saw them and she pulled up with the purpose.
She saw them and pulled up with a purpose. Why did she make a U-turn, right? If she's so, she's trying to stalk Carlos or whatever, why didn't she just go right down to Carlos' house?
Because he went at his house, obviously, and she saw him out and about and with Holly.
So you're saying that she saw them, and that's what made her make a U-turn. And
I'm assuming that. I'm assuming she had to see them, because why in the world would she pull up if she didn't see them?
Why would she get in her vehicle if she seen them instead of just running directly across the street and leaving her car in the park?
I mean, because that's a good little ways. It's not right across the street like you think.
It's right across the street, Amora.
No, it's not. Let's be honest. Matter of fact, let's measure it. Okay, let's do that. Let's do that. Okay, let's measure. We're gonna measure from. Let's go back. We're gonna measure it. We're gonna measure it. Okay.
Whether you measure it, it's across the street, love.
It's across and down the street. Let everybody think across the street. When you tell somebody across the street, but we're gonna measure it right quick. So right here, hold on. Let me get my little measuring stick.
You would walk around that island and not just step over that little low curb island and go across the street?
If I have my car, why would I do that?
Because
why would I do that if I have my car?
Why do you need your car to approach someone? If you're trying to run up on,
if you're trying to get there quicker, I'm gonna go a little further and say she had already left the school. She had already left the school. So, you know what I'm saying? While she was at the school, she probably didn't see him. But she had already left the school. She was looking for that joker. That joker turned his phone off and didn't answer her no more. And she got mad.
Well, what about him looking for her since August 20th? He's been looking.
But that don't have nothing to do with September the 8th.
It don't. If she looking for him that morning has something to do and so pertinent to September the 8th, him looking for her every day since August the 20th.
And I don't know about that, but I would ask him. But I'm gonna say I don't believe that, because he said that he had already started back talking to him. And then listen to this. You say he was looking for her. He was looking for her. Then if he's looking for her, then why is she calling him that morning and asking him to take his son to school if he doesn't know where she's at? If she's missing, all of a sudden, out of the blue, she's calling him and saying, "Can you take Lil Los to school?" She wasn't that missing.
What do you mean she's missing?
You just said he was looking for her, right?
Yes, he said he was looking for her.
If he was looking, what do you mean looking for her? Like he didn't know where she was? Like she was missing?
He's the one that said he went up to her job.
He told me he went up to her job to tell her supervisor to stop her from fucking with him.
Okay, so he was looking for her.
He wasn't looking for her. He was telling on her.
Why didn't he tell the police?
I don't know. You got to ask him that. But what does that have to do with her that morning saying, "I need you to take Lil Los to school"? And he's like, no, you need to take him. You already running late anyway. You go ahead, take him. And she calling him 10 times, back to back, until he turned his phone off.
Okay, maybe.
And I say 10, but hell, it probably was more than that.
Maybe she was on her baby mama-ism on take your son. She ain't want to take no for an answer on him dropping his son off. That was the purpose in him having his son in the school district where he lives, right? And she no longer staying if he ain't trying to participate in being a co-parent.
Come on, Trina. Now, don't you think that something like that needs to be coordinated? You don't just at the very last minute, I'm late. And maybe he already had something else to do. And obviously he did.
Girl, he lived down the street and he don't got no job. He worked out at the gym.
And he probably was trying to avoid her running into Holly.
He been having Holly upstairs while Romika downstairs, and Romika ain't know. Just get your son.
No, that don't have anything to do with anything. That has nothing to do with anything. The fact that he told her he wasn't going to be able to do it, for her to do it, she had no reason to bust at you. She had already dropped him off. She's already late, so go to work. If you late, why you ain't go to work?
She was busting to you to go to work.
No, from what I was told, which I don't know, because I don't know where she works, but from what I was told, her job would have been making that right turn, not busting a U-turn.
In order for her to get to work, she would bust a U to get there more efficiently. She does not work east of this.
Okay, you're the only one to have said that. Other people from Chicago have told me differently. But you know what? I don't know. That's for them to figure out, to be honest with you. So, but anyway, even if like someone said in the comments, even if she did bust the U to go to work, why did she stop? She's already late. Why stop?
Because she seen her baby daddy, right?
With the woman that she has threatened to beat her ass.
That she just asked multiple times to drop his son off at school, and he didn't even answer the phone. To what
he did answer. He told her no.
He told her no, but what about the other 10 times that she called?
I mean, goddamn, how many no's does it take?
Okay.
Would you keep on if somebody told you no? Would you keep on? Would you keep on and keep on and keep on and keep on?
In specifics, would I consistently do what Mika did with my child's father? Yes, been there, done that.
Oh, you'll just keep on calling him, no matter if he said no or not. You just blow his phone up and you just gonna change his mind, huh? Yeah, I don't know how y'all are with y'all baby daddies, but you only got one time to tell me no.
Knew that at the end of the day, we stayed together 17 years. I knew at the end of the day, when I get off from my shift at the hospital, it's gonna be some fucking shit. Because if I'm saying I need you to get the kids, I need you to get the kids. Stay on my ass and my job on the line.
Well, she told him she was late. He said, since you're already late, you might as well just drop him off. Go ahead and drop him off. So she dropped him off. If you late and if you all about your business and you trying to go to work, why don't you go to work?
I know that I couldn't go to work unless this nigga was here. Because I wasn't paying no child.
Unless he was what?
Unless my child's father was home from work, I could not leave and go to work. I wasn't paying for child care for 2 children. You see
what I'm asking you is, the baby is at school now. The baby is dropped off. She left the building at 8:53. Okay. So now, why didn't she go to work?
I guess she was on her way to work. But
until she saw them.
And she saw them, and what happened?
And she pulled up behind them and started an altercation.
Did she pull up behind them and start an altercation? What proof do we have of that?
Well, you got the police report for one, and then Holly and Carlos was on the scene.
What do the police report say?
The police report says that she pulled up and an altercation ensued, and then she started battering Holly. That's what the police report says.
What police report is that?
Let me go get it. Right here. What does that say? Per Officer Vera. Per Officer Vera, witnesses on the scene reported that Blackman came to the residence of her child's father and the father's female significant other. Blackman began arguing with the female significant other, which escalated to Blackman battering her. So Blackman was battering her. The female significant other then took out a firearm and shot Blackman once in the chin and once in the thigh. Neighbors reported hearing 5 total shots. This is when emergency services was notified and discovered Blackman lying in the middle of the street with the multiple apparent gunshot wounds. Police confirmed the female significant other was currently in custody. Approximately 3 shell casings were located on the scene, and the suspect firearm used in the incident was recovered by the police. Boom, boom, boom.
And so where did they get that information from?
it says per Officer Vera and witnesses on the scene.
Okay. And so what witnesses told Officer
I'm not
Vera?
sure. It doesn't say. It
Because
don't identify them.
why and how? How would the witnesses know where Carlos lived?
It didn't say where he lived. It just says came to the residence. I mean, it was parked. It wasn't his residence like his home, but that's where he lived around the street. That's where she was parked.
Where the incident happened is not his residence.
Well, it's an extension of his residence. That's where his guest parked.
He does not live in public.
It's not like he was at Kentucky Fried Chicken, is what this thing is saying.
Laura, where the incident happened, that's Chicago housing projects. Carlos don't.
Well, you have to get on Officer Vera for that one.
Why did
Carlos did not write this up. The Officer Vera did, or somebody.
Why?
It says per Officer Vera. So you said who said this? Officer Vera said it.
Why would Officer Vera think that was his residence?
You have to ask Officer Vera. But it says that they began arguing with the female significant other, which escalated to Romika battering her. Battering. You know what that means?
I do.
Yeah, so that means that it went from an argument to her putting her hands, putting her paws on somebody else.
Weird or indirect contact. Okay.
Well, if they were arguing and it escalated to battering, then that means that she was
battering can mean absolutely the swing or Ramika, making that swinging or swung on Holly that the witness, who was Carlos, stated, and then other legal documents of Ari's. So we know that, Carlos made the statement that Romika swung on Holly. That can absolutely be the battery.
Okay.
Unless you're
and to be honest with you, because there is no video footage, then the state has to disprove that.
Why does the state have to disprove?
That's the law. That's not a Morris law. That's Illinois law. That's your state.
Why does the state have to disprove what the
because they have to disprove self-defense?
No.
Yes, they do. The burden of proof. The burden. Look it up, Trina. The burden of proof. Hold on, say it with me. The burden of proof is on who is accusing you of this. If you accuse me, okay. If I accuse you, hold on. If I accuse you of something, is it up to you? Hold on. If I accuse you of something, if I accuse you of stealing, if I'm a Walmart manager and I accuse you of stealing, do you have to prove to me that you didn't steal, or do I have to prove to you that you did steal?
As the manager, you're going to call the police and whatever I need.
No. But if I accuse you of stealing, do I have to prove that you stole, or do you have to prove that you didn't steal?
I have to prove that I did not steal.
I have to prove that you did.
Correct. And so
which means the state is the one that's accusing Holly of a crime. She has to prove that it was not.
Accusing her of first-degree murder.
Right. They accuse her of first-degree murder. They have to prove, and she said, no, I didn't. It was not first-degree murder. It is self-defense. They have to prove, no, it's not self-defense. It's first-degree cold-blooded murder. But Trina, I know you know this. Like, I know that everybody in these audience know the burden of the proof is on the state.
And all the state has to prove is that Cordasia intended to cause great bodily harm.
That is not true.
Why?
They have to disprove self-defense.
That's what first-degree murder is.
But look up self-defense. Look up how do you beat self-defense in the state of Illinois?
How do you beat self-defense? I don't know
exactly. So let me say it to you correctly.
self-defense
Let me say
case?
it to you correctly.
Who's fighting a self-defense case?
I'm gonna say it to you correctly. Once self-defense comes up and is accepted by the courts, which it is, then it's up. Then the proof, the burden of proof, is shifted to the state. It shifts to the state.
The state has to
disprove
charge.
They have to disprove self-defense.
Their charge beyond a reasonable doubt.
So you've never heard of self-defense? So you've never heard of a self-defense case?
Self-defense is not a charge.
Oh my.
Have you ever heard anyone being charged with self-defense and being arrested for self-defense, Amora?
Nina, what I'm saying to you is, if a person says that they did not commit the murder, it was self-defense, and self-defense is not murder. If they say it was self-defense and self-defense is accepted by the court, then the state is fighting against self-defense.
Amora, she has 6 charges.
It's not 6 charges. Come on, let's get that right. It's 1 charge of first-degree murder on 6 different counts. And that's just 6 different ways that they can find her guilty. But if self-defense win, none of those counts matter.
Hold on, Amora. You said that 6 different ways they can find her guilty. But you've been telling people
6 ways. Yeah, 6 different ways.
You've been telling people that it's all or nothing. That either it's first-degree murder or Holly walks.
So listen. First degree is the charge. Charge and counts is different, okay? First degree is the charge. It's the same charge. First degree is the charge. If self-defense cannot be disproved, then none of that other stuff matters. Everything is gone.
If
the state cannot disprove self-defense.
You just stated that first defense is the charge, right?
The charge is first-degree murder, is what I'm saying to you.
Okay.
However, self-defense is her defense. So let me ask you something. So you know a defense have to have a reason why they did it, right? I did it because of this. I did it because of that. Her defense is self-defense.
I know that, but you're stating, and everybody knows that first-degree murder is the charge. That's the charge. And so the state must prove their case. The state is saying
that's right. You're right. The state must prove their case, which means that they have to discount self-defense. They have to eliminate self-defense.
That would include improving their case, Amora.
What do you mean improving? Oh, you said proving. Yes, they have to eliminate self-defense. If they cannot eliminate self-defense, then they don't prove their case.
Would be included in the state proving its case of first degree.
But they can't. How are they going? Tell me this. How are they going to disprove self-defense beyond a reasonable doubt? Let me know.
They have to prove first-degree murder beyond a
reasonable doubt. Oh my God. No, they okay. In proving first-degree murder, okay. In proving first-degree murder, they have to disprove. In order to prove first-degree murder, they have to disprove self-defense, is what I'm trying to say.
They have to prove first-degree murder beyond a reasonable doubt. Do you agree or don't agree? Do you agree or don't agree that the state must prove that Quadasia Johnson committed first-degree murder beyond a reasonable doubt?
Yes. However, now listen to me. And the only way they can prove first-degree murder is they have to disprove self-defense beyond a reasonable doubt. One cannot happen without the other. The state of Illinois cannot prove self-defense without disproving, the state attorney cannot prove first-degree murder without disproving self-defense first.
Are you understanding the argument? And
Are you understanding what I'm telling you? It's a self-defense case.
Absolutely not, Amora. The state has to prove.
I can't believe I'm going back and forth with you on this.
Holly's defense is self-defense. She's saying, I did not commit first-degree murder. This was self-defense. The state is going in to prove first-degree murder. Ari's going in to prove Quadeja acted under self-defense. Okay?
No, Ari does not have to prove that. The state have to disprove it. Hold on, let me just put it in here. If a person is charged with first-degree murder, hold on.
Whatever you got to do.
If a person is charged with first-degree murder and the defense is claiming self-defense, what does the state have to prove? Okay.
Screen so everybody
I'll show it on the screen. I'll show it on the screen. I'll even let you hear it. All right, here we go.
And you actually could have put in the state of Illinois.
But don't know the law. I'll break it down clean, Illinois style, because that's where this confusion keeps coming from.
Can you hear it?
When the charge is first-degree murder and the defense raises.
Can you hear it?
Step 1. What the state must prove. First, beyond reasonable doubt, before self-defense even comes into play, the state has to prove every element of first-degree murder. The state must prove that the defendant, 1, performed the act that caused the death, and 2, did so intentionally or knowingly, or 3, knew the act created a strong probability of death or great bodily harm. If they fail here, not guilty. But let's assume they clear that hurdle. Step 2. Once self-defense is raised, this is where people get lost. In Illinois,
can you guys hear that?
Something the defendant has to prove. Once any evidence of self-defense is introduced, even minimal evidence, the burden shifts into.
Do you hear that, Trina? Y'all not answering. Can y'all hear that?
Yeah, we hear.
Oh, I didn't know. Let's start over. I'm sorry. I didn't know y'all heard it. I kept asking. Hold on.
Question. This is the core issue people keep missing when they talk loud but don't know the law. I'll break it down clean, Illinois style, because that's where this confusion keeps coming from. When the charge is first-degree murder and the defense raises self-defense. Step 1. What the state must prove. First, beyond a reasonable doubt, before self-defense even comes into play, the state has to prove every element of first-degree murder. The state must prove that the defendant, 1, performed the act that caused the death, and 2, did so intentionally or knowingly, or 3, knew the act created a strong probability of death or great bodily harm. If they fail here, not guilty. But let's assume they clear that hurdle. Step 2. Once self-defense is raised, this is where people get lost. In Illinois, self-defense is not something the defendant has to prove. Once any evidence of self-defense is introduced, even minimal evidence, the burden shifts entirely to the state. What the state must disprove beyond a reasonable doubt. To defeat self-defense, the state must prove at least one of the following beyond a reasonable doubt. The defendant did not reasonably believe deadly force was necessary to prevent imminent death or great bodily harm or a forcible felony. Keyword reasonable, not perfect. The defendant was the initial aggressor, meaning she provoked the violence and did not withdraw or try to disengage. The threat was not imminent. Threats still matter if they explain fear. Imminent, already happening. Imminent, about to happen. The force used was clearly excessive. The danger must have ended. shooting after the threat ended can defeat self-defense. Here's the part. Social media gets wrong. If the evidence shows two reasonable interpretations, one that supports guilt and one that supports self-defense, that is reasonable doubt. The jury must acquit. The state does not get to say, open quote, well, we don't believe her. Close quote. Disbelief, proof. Important legal reality. The state does not need video, does not need to prove motive, does not get to ignore threats, history, or context. But they do have to eliminate self-defense beyond a reasonable doubt. And that is a very high bar. Plain English. For a conviction, the state must convince all 12 jurors that, open quote, there is no reasonable possibility that this was self-defense. Close quote. If even one juror believes self-defense is reasonably possible, not guilty.
Boom.
Next weekend, apply this step by step to a real fact pattern, or break down.
All right. Did you hear that?
And so I heard that. Can you give me permission to present my screen so I can show you the law?
Sure. But did you not just hear what it said? Put your stuff up. Let me see it. Put your stuff up.
I heard that. So
now, did you understand what I was saying?
you're saying that her self-defense claim applies because she feels that she was in imminent danger of great bodily harm or death, just like, it's like the opposite of first-degree murder. And
Well, no, I'm not saying that now. I'm saying she believes that she believed that she was defending herself, which means that she is exercising her right to claim self-defense.
Okay, and it's also not proportional, okay, because Romika does not have a weapon.
You don't have to have a weapon. I thought that I already went over there with the case law.
Have to have a weapon, but the force Romika.
You don't have to have a weapon. You know this.
In order for that proportionality to stand, that person needs to be beaten the shit.
That's not true. Actually, do you know that you could use a weapon even if the person has never even laid hands on you? If they are running toward you in an aggressive manner after they have already made threats to you and your child is in the back seat, they don't even have to make contact.
Okay. I don't know about in Texas, but this is the state
I'm talking Illinois. This is the Illinois law.
This ain't the Wild Wild West.
I'm trying to tell you, they don't even have to make contact. This is the law. This is not Amora. This is the law.
Amora, are you going to show?
You can look it up.
Are you going to show the law?
Okay, what's the law? Hold on.
Are you going to
please explain the law that justify deadly force in the state of Illinois?
He's in here talking about Holly had her child on the scene. Well, why didn't her or Carlos mention Romika going after the child?
No one said that she went after the child.
Okay, so her child was there with her the entire weekend. So what, your child is with you?
The child was on the scene. What are you talking about? That matters. Are you kidding me?
Is her
Do you really think that that's not going to matter? Because in a self-defense, the state allows you not only to protect yourself, but it's called protect the person.
And there's no one saying, like you just stated, okay, because you just state, nobody's saying that she went after the child. If nobody's saying she went after the child, what are we talking about? What are you talking about? Her child was on the scene. Okay.
Because hold on. Let's listen to this.
Many children were on the scene going to school, Amora and Tim.
Okay, let's listen.
How many children go to the National Teachers Academy? And how many children?
I want you to hear this.
Holly's not Octomom. She has one child.
I want you to hear this.
Of children that go to school at National Teachers Academy.
I'll focus on 7.1 because that's what applies most often. The core rule, the legal standard, a person is legally justified in using deadly force in Illinois if, open quote, They reasonably believe deadly force is necessary to prevent imminent, close quote, death or great bodily harm or the commission of a forcible felony. That's it. No extra fluff, no social media add-ons. Let's break that down. This is where people
What this says.
reasonably believe. This is not perfect judgment, judgment made with hindsight. It is what a reasonable person would believe in the same situation, knowing what the defendant knew at the time.
That client.
You said that they have to be getting beat the fuck out of in order to protect themselves.
That
I'm
client.
telling you, and I'm telling you, they do not. I'm telling you, they do not.
He said that, but why is that playing while the law is showing? And why do you got it so small? Let the people read 720 ILCS 59 through 1. And what it says, first degree murder is. Now you don't want them to read, Amora?
What are you even talking about? I don't even know how to make this big. That's the biggest I can make this. Hold on.
Make it.
And I'm sure you guys StreamYard, so you already know what we're working with over here. So this is the biggest I can make this. And so read it. Read it. If your material, read it.
Under this statute, first degree murder is defined by the mental state of the person at the time of the act. The specific
Do you know what that means, the mental state?
The specific language regarding intent and great bodily harm is found in subsection A. A person who kills an individual without lawful justification commits first-degree murder if in performing acts which cause death. Number one, he or she either intends to kill or do great bodily harm to that individual or another, or knows that such acts will cause death to that individual or another, or he or she knows that such acts create a strong probability of death or great bodily harm.
Your phone is going in and out.
I'm sure it is. To that
It actually is.
or another. Okay.
So you missed something. You missed something very important. Let's go back. The very first sentence says what? Under the statute, first degree is defined by, wait a minute, hold on, let me go back. No. Where it says up under a person who is killed an individual without what?
You read it. I just read it. You
So
read it.
a person who kills an individual without lawful justification. Do you know self-defense is a lawful justification?
That's her perception.
So can you put in your Gemini? Can you put in there, is self-defense a lawful justification?
If she can prove that she acted.
She does not have to prove it, Trina. The state has to disprove it.
The state only has to prove that she
Oh my God.
caused
Trina.
harm.
Trina. Okay, ask it. Does the state have to disprove self-defense? Put it in there.
In disproving self-defense.
No. Just ask it. Does the state have to disprove self-defense?
They don't.
Well, why don't you put it in there? Why are you scared to put it in there for everybody to see? Are you afraid of what they might see? She's slamming them keys, y'all. Does the state have to disprove self-defense? Girl, I'm glad them damn keys ain't on trial. Shit. Dun 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 dun. All right, what did it say? The state must what?
In Illinois, the answer is both. The state carries the ultimate burden of proof throughout the entire trial. Under Illinois law, here is how the legal works when self-defense is raised. the state must prove the elements of murder. First and foremost, the prosecution must prove the basic elements of first-degree murder beyond a reasonable doubt. That the defendant performed these acts that caused death, that the defendant intended to kill or cause great bodily harm, or knew their acts created a strong probability of death or great bodily harm. Number two, the defendant raises the defense. The defense
Exactly.
is highly self-defense.
So do you know what raising self-defense means?
This is an affirmative defense. This means the defendant has the initial burden of production. They or the evidence presented must provide some evidence of self-defense. This is a very low bar. It just
Say that
needs to be
Say that again. It's a what? It's a low bar, right? You know what that means? The only thing he has to say is, I was afraid for my life. Boom.
Because you're over talking me and you said that's what the state must prove. Number three, the state must disprove self-defense.
Exactly.
Evidence of self-defense is on the table. The burden
Right.
goes back to the state. The prosecution must disprove
The claim.
defense beyond a reasonable doubt. To win a
Okay.
conviction, the state must prove that at least one of the following elements of self-defense was not present. Force was threatened against the person threatened was not the aggressor. The danger of harm was imminent, and it says one, not all of them, just one. Just one. Not all
It
of
says
them.
one must not be present. One must not be present. What's not present? Tell me what's not present.
Don't talk over me because I'm reading and you ain't. You want to read it, you can, but read it in its entirety.
Okay, but you literally just proved my point.
To win the conviction, the state must prove that at least one of the following elements of self-defense was not present. So just one of these elements was not present. That force was not threatened against the person threatened was not the aggressor. The danger of harm was imminent. The use of force was necessary. The person had a reasonable belief that a danger existed. And also, the state is going to go with three of them. The danger of harm was not imminent. The use of force
Say how they're going to prove that.
necessary. And the person was not reasonable in the belief that a danger existed.
Listen, it says a person had a reasonable belief. How are they going to prove if she had a reasonable belief or not? Now, here's the thing. Now, I want you to ask your Gemini, is this easy to do? And how is it going to be done? How the state is going to do it?
I'll better for you.
See, I already did my homework. Laughing because she mad at them damn keys. So what'd you say? You said, will this be easy for the state of Illinois to do in the case of the people versus Cordasia Johnson? You say, okay. You want me to read it or you? Yours speaks slow, mine is fast. All right, it says, wait a minute. Okay, it says determining whether a case will be easy for the state is complex. Okay. As it depends entirely. Hold on, let me put you on mute. All right, it says, let's have echo. Okay. It says determining whether a case will be easy for a state is complex, as it depends entirely on the weight of the evidence and how a jury perceive the reasonableness of a defendant's action. In the case of the People versus Cordeja Holly Johnson, there are several specific factors that could make the state burden either significantly lighter or more difficult. Factors making it easier for the state. The state has several tactical advantages in the specific case based on the reported evidence. Surveillance video. Prosecutors have stated there is video of the incident on South Loop. That's not true. There is no video. What is this talking about? Prosecutors have stated there is video of the incident in the South Loop. There is no video.
Video.
In modern
Video.
there is
The school video. We just talked about the video in Ari's motion.
it says of the incident. It
Yeah.
says of the incident. There is no video of the incident.
Okay.
The boom, 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 boom. There's no video of the boom, boom, boom.
Well,
It says modern trials, video is silent witness.
include Romika making the U-turn. Why is it in Ari motion? That's
Okay, let me.
incident.
If the footage shows Cordeja Johnson as the aggressor, if the footage, the video footage that Trina says that the state has, if it shows that Holly was the aggressor or shows the victim Romika was unarmed and not posing an immediate physical threat, then the state job of disproving self-defense becomes much simpler. Boom. But we know there's no video that shows that Holly was the aggressor. And we know there is no video that shows Romika was just calm and just unarmed and imposing no threat. There is no video.
If
So
there's
let's
no video that show Holly as the aggressor, it's no video that show Romika as the aggressor. Because in order for it to
and you're right. You're right. So guess what? Wait a minute. Hold on. You're right.
show Holly,
Trina, you're right. If there's no video showing Romika as an aggressor, then there is also no video showing Holly as an aggressor. So then guess what happened? Reasonable doubt. And they have to eliminate reasonable doubt. Okay. So let me finish. Now it says the fact that a judge, it says bond denial. The fact that a judge denied her release and ordered her to remain in custody as of January 2026 hearing indicates that the court found the state proffer initial summary of evidence strong enough to meet the high bar for detention in a murder case. That's just detention. Duty to retreat, contextual. While Illinois does not have a stand your ground status, the law still looks at whether the use of deadly force was necessary. If the state can show Johnson had a safe way, not any way, but a safe way to leave the confrontation, but chose to use a firearm instead, her self-defense claim is weakened. Well, we already know she was blocked in, so she didn't have no safe way because the car didn't have wings. Okay, factors making it harder for the state. Let's go. Conversely, the defense has pointed to evidence that could create the reasonable doubt needed for an acquittal. 911 audio. The defense has cited 911 recording, which they claim, hold on, you just moved it, which they claim support Johnson versions of events, that she was the one in fear of seeking help. If the audio captured her sounding truly, what is this? Because there is no audio of her sounding truly terrified. Your AI is a lie, honey. You need to go put your AI through. Your AI needs a goddamn lie detector test because your AI is a whole lie. There is no 911 audio of Holly calling in and DS. So your AI is a lie. You need to pull up the truthful AI. Girl, your AI is a liar. Anyway, let me finish reading your line AI. Your line AI said that there is a 911 recording claiming that support Holly Johnson. This line audio said that she was the one in fear and seeking help. If the audio captured her sounding truly terrified or trying to de-escalate, then it supports her subjective belief that she was in danger. Then it goes on to say the Carlos Smith factor. The man at the center of the dispute, Carlos Smith, has publicly contradicted some of the state's claim such as the allegation that there was a fist bump Johnson after the shooting. If a key witness for the state is viewed as unreliable because they told that boldface ass lie or biased, the prosecution narratives can crumble. A valid CCL license. The fact that Holly was legally licensed to carry a firearm, CCL, means she was not looking for trouble in the eyes of the law by simply having a weapon. The defense will argue she was a law-abiding citizen forced into a life or death moment, which she was, and had her CCL for a while. The legal turning point, reasonableness. The entire case will likely hinge on Illinois pattern jury instructions 24-2506. The state doesn't just have to prove Johnson fired the gun. They have to prove that her belief, not Trina belief, not Amora belief, not the Pink Mafia's belief, not social media belief, but her belief, Holly belief, that she was in danger of death or great bodily harm was legally unreasonable. If the jury finds her belief in danger was reasonable, then the result is not guilty, self-defense. If the jury finds her belief in danger was unreasonable but sincere, then second degree. If the jury finds she had no belief in danger, act out of malice, then first degree, 20 to 60 years. Now, we already know she ain't going to get no 20 to 60 years because we know that there ain't no belief in there and no acted out of malice. But I want you to put in your lying AI, how in the world can they prove that Holly did not believe that her danger was reasonable? We waiting.
Why is you trying to insult Gemini?
Because, honey, Gemini said that there was a 911 call that Holly made and sounded in fear of her life. Now, I don't know if you put that in your AI or somebody put it in your AI.
Back and read. Maybe your eyes is tired. Okay. It says, conversely, the defense has pointed to evidence that could create reasonable doubt needed for an acquittal. 911 audio. The defense has cited 911 recordings, which they claim support Johnson's versions of events. So they're claiming that the 911 calls support Holly's version of events, that she was the one in fear and seeking help. If the audio captures her sounding truly terrified or trying to de-escalate, it supports her subjective belief that she was in danger. So how is this a lie? Where's the lie?
What it should say is, because this is what the defense said about the 911 audio. The defense said that the person that called in for 911 said that Romika was the aggressor. Said the one that's in the red hair was the aggressor. That's what was said in the 911 audio, that the girl in the red hair was the aggressor.
And it says the defense cited 911 recordings, which they claim support Johnson's version of events.
But let me go a little further. You want to know what else supports Johnson's version of events? Do you want me to tell you that, Trina? Let me tell you. Where did the body fall?
You do know that Carlos stated that he moved Romika out of traffic, so I'm not going to even discuss where the body fell because there's accurate video. There's no video of her actually being shot and falling. So he's already admitted to moving her body, so I'm not going to even do.
Okay, so Trina, I'm just going to ask you this: if he moved her body,
why did he move her body?
So let me ask you this, Trina: if he moved her body,
why did he move it?
Let me ask you this: if he moved her body,
he said he did.
I'm asking you though. So I'm asking you. I'm talking to you. I'm not talking to Carlos. I'm talking to you. If he moved her body, then
video.
Would they be a blood trail, Trina?
Everybody knows.
Come on, I know you're smarter than that. Would there be a blood trail?
She moved her body and her blood spilled into the streets with no specific pattern whatsoever. She bled out on the scene. Are you serious? Do you see the amount of blood?
Okay, but if he moved her body, then where did she bleed out at? Where she first landed, or where she was moved?
He moved her body. Now that's your man's. Call him and ask him.
Okay, so guess what though? So the evidence, no matter what Carlos say, no matter what witness number 3 say, no matter what the witnesses say, it does not override what the evidence proves. What does the evidence prove?
What evidence do you got?
Okay, let me show you.
As far as the position of Romika's body, and is that more or after he moved her body? Because if you can't show me when she's being shot and falling down right where she was, then you don't have evidence because you don't have a proper timestamp. When did he move her body? He's saying immediately, so she wouldn't be.
So you do know blood is a very
He did. Now stop. How y'all gonna?
So where's the blood at? Tell me. Where's the blood?
It's everywhere.
Where at? Besides just right there. Where is it at? If he moved her body, where did he move it from?
It's everywhere.
Okay, so let me ask you this. If he moved her body, why she has blood on the car?
You're wanting to argue a post-mortem.
No, why she have blood on the car? If they move the body, why does Holly Carr have blood on it?
Romika. Why did she shoot her?
Because Romika attacked her.
Because Romika attacked her. Where's the proof? Where's the video? Carlos got video.
There is no video. There is no video.
Video of Romika doing everything to him. Everything. So
you think he was supposed to whip out a camera that day?
No, the attack.
So he was supposed to whip out a camera that day?
He had 2 phones.
So he was supposed to be de-escalating. He was supposed to be
out while he was beating her ass. Hell yeah.
So he was supposed. So he was
2 phones.
Yeah. Okay.
Where was from? You're saying Romika was the aggressor after you already said there's no video proof or evidence of that.
But you said it was.
You consistently saying that.
But you said it was.
I said what?
That there was video after I told you it was not.
Video of what?
The incident. That's what your AI said. Incident. Your AI said that there was video footage of the incident, and I said it was not. You said yes, it was.
No, you're saying it was me that said it was video of the evidence or the incident.
No, I said your AI said it, and when I asked you about it, you said yes, it was.
I say it was video of the I just pulled up my AI. You want
your AI said
advantages of this specific case based on reported evidence. Number 1 is surveillance video. Prosecutors stated there is video of the incident in the South Loop.
So video of the incident, right? What is the incident?
You define the incident. I say the incident started obviously when Romika made the U-turn or her leaving the school, since it's in legal documents. That's
not the incident. The incident is why Holly is being charged first degree.
Why does it matter when she left the school, and why did you make it such a big point if that's not part of the incident?
But if you continue reading, what does it say? If footage show what? It don't say if footage show Holly busting no U-turn. What does it say? If footage show what?
You talking about this lying
AI? Yeah, you're lying AI.
So you're saying if the footage shows Quadasia Johnson as the aggressor, or it shows Romika Blackman was unarmed and not posing an immediate threat, the state job of disproving self-defense becomes simpler?
Yes. So the incident, it says it has surveillance video of the incident. And I'm telling you, there is no surveillance video
says
of the,
prosecutors
because
have
if it
made
was, then Holly wouldn't have never been charged. If there was video footage, Holly wouldn't have never been charged.
You're saying if it was video evidence that Holly would never been charged, why?
If it was video footage of the incident itself, then Holly wouldn't have never been charged because it would have shown that Romika was the aggressor. Romika aggressively ran up on her and Romika attacked her and Holly defended herself.
You're saying that there is no video of the incident. So why is Quadeja charged? You said
Quadeja's charged because the probable cause is very low, right? So probable cause was met. So they arrested her and charged her because of probable cause. A murder did happen.
what?
They don't know, and
What?
they are allowing.
Okay, well,
Well,
Laura, you're saying that
and let me take that back. Not a murder, a death happened because of
probable
offenses
cause,
murder.
Laura, you're saying that probable cause was met, right?
Probable cause, yes, which is a very low threshold.
It's different between September
Probable
8th,
cause
58 days after.
Probable cause don't win cases. Beyond a reasonable doubt does. Probable cause does not win cases. Probable cause is a very low threshold.
This is what you're saying. This is your opinion. This is not the truth. Why? But explain to
It's
me.
the law. It's the law.
You're saying your opinion. That's not the truth.
No,
What?
it's the law. I'm telling you what the law says.
What is? And I'm asking you, what is the probable cause? 88 days later from September the 8th. Probable cause. Yes, day one. That would have been okay. That's why they're making an arrest. But 88 days later, why did they arrest her?
Actually, to be honest with you, that's going to come back and haunt the state.
Oh,
Not you need to come in. Okay. Not arresting her for 87 days. They're basically saying that they didn't see a reason because they saw that Holly did everything right. But because this is a high profile case, they want the jury to decide. That is why they waited, because they already had witness number 3 statement. So I know they didn't just arrest her because of that. They don't have nothing else but those witness statements.
we have murderers on TV all the time in Chicago. Right? This is Chicago. So it's
I
not
understand that.
that.
What I'm saying to you is that 87 days of not arresting her is going to come back to her state.
And so what do you think that they gathered in those 87 days?
Not shit. Public scrutiny, social media scrutiny, the family coming down bugging the dog shit out of them. That, but no additional evidence. No.
Do you know how many
The evidence actually hurt the state.
murders
The evidence The evidence discount witness number 3 saying that Holly was disengaged, and that's Holly, but Romika was disengaging and walking back to her car. So the evidence actually disputes, cross out witness number 3's statement. Would you agree or disagree?
Hey, you're saying there's no video of the incident. Why did you mute my mic? It says, okay, you unmuted me. Why? There's no video footage of the incident. So how?
Which makes the state case harder to prove. Which makes the state case harder to prove. That right there is the biggest reasonable doubt, because there is no video footage showing what really happened. That creates the biggest reasonable doubt of them all.
There are witness statements.
The eyewitness cannot override evidence.
There is video of various videos, right? You got the Sharks
Not of the incident.
motion, the Sharks Cam and Ari motion, the school videos in Ari's motion.
Showing Romika stalking them. So how does that hurt Holly?
Why isn't that in Ari's motion?
Listen, we're not about to talk about what's in her motion. We're gonna talk about what we're talking about right now is how is the state going to beat this beyond reasonable doubt? Did you know, Trina?
They
If
only have to prove one
okay,
of
Trina.
those
All
multiple
right. Well,
elements.
thank you for coming on the panel. I'm letting you know now. You're gonna be the biggest. You're gonna be the most disappointed of them all.
I am
And
going
and,
to
and I will. You give me your address, and I will send you 10 boxes of Kleenex after they leave trial. I have you on that. I got you 10 boxes of Kleenex. Okay.
Well, I'm still waiting for you to eat that crow. Now,
Okay. Well, on that day, I'll eat crow. And you can send me 10 boxes of
she eat
Kleenex. Okay.
crow on her non-release at the last court date. Come on now.
Well, I've already ate that crow. But I'm telling you, detention and trial is two different things. Beyond a reasonable doubt.
Are you
Okay.
of the big nose fiance scarecrow or actually a crow?
What? I don't know. I don't know Ebonics, so I have no idea what you're talking about. All I'm saying is
Already ate the crow. I'm just
when at the trial, because here's the thing: detention is one thing, social media is another thing, the trial and the jury is another thing. Okay, so your state attorney has to beat this case beyond a reasonable doubt, and
No,
they're not going to do it.
the case. The state attorney got to prove the case.
They got to disprove self-defense. They have to disprove self-defense. All Holly and the defense attorney has to do is raise self-defense, which is raised, and the state and your state attorney has to disprove it. So I'm ready to watch your state attorney do their work.
You can play semantics all day long.
Okay, well, where you want me to send the tissue to? Tell me. Am I sending it to Cermak or you got another address? Like, where do you live? Because that's where I'm going to send it to. But let's just wait until the outcome, and then I want you to come back over here and give me your address so I can send you this tissue. Make sure. Let me go to Sam's and get it on sale. Okay, get it upon you.
You sent the Amazon gift card. Send it to that same address.
All right, I'll send it to the Amazon gift card.
I'll send it
to the Amazon gift card.
You
all right.
Amazon.
But I'm letting you know now, you guys, right now, y'all have Jello. Your case is weak. Your case is weak.
She would still be free, would she not?
Not true. Not true. Detention and trial is two different things. Your case is weak, and unless y'all come up with more evidence, I'm gonna need y'all to bend over and pull something else out y'all ass, because unless y'all provide more evidence, the case is weak. What's making y'all happy and excited right now is because she's in detention. Detention and the trial is two different things.
After they detained her, what makes you think it's less evidence after they detained her?
Listen, evidence for detention is so different than evidence for the trial.
Her ass is cooked. She didn't even know she was under surveillance for 88 days.
It don't matter. It don't matter. She could be on surveillance for 20,000 days. I'm
of that.
to tell you, detention, and I know you know this. Detention and trial is two different things. Listen, trial is. So tell me this. Tell me this. How is your attorney? How is your attorney going to disprove beyond a reasonable doubt?
What?
Yeah. Tell me. Don't get excited. Just tell me. Speak.
That's a crazy ass question.
Okay, well, answer the crazy ass question. Answer the crazy ass question.
I'm going to give you a chance to rephrase that question.
Okay, let me rephrase it.
Again.
How is your state attorney going to disprove self-defense beyond a reasonable doubt?
They have to prove first-degree murder beyond a reasonable doubt. And would include
and improving first degree. Improving first degree. Improving first degree. They gotta disprove self-defense in order to convict her.
How is self-defense? Because I've been to multiple universities and I could tell you.
Okay, where's your degree? Post it. Post it. Post your degree. Post your degree.
Okay,
Post your degree. Post it.
pay up. Say I ain't got one. Pay up.
Now, I told you to post it. What I gotta pay you for? Hell, your degree costs money now.
You want
To
me to
see
pay
your
you
degree costs money.
shit? And
To
which
see
one?
your degree costs money.
Hell yeah, because you ain't
You should be.
you ain't posting yours. Where yours?
Which one? How many you want to see?
Either we
One
gonna
of-
degree for degree, or we you ain't talking about shit.
Okay, let's
I
go.
got mine.
Okay, let's go. Let's go. Post it. We can post it at the same time. Let's go.
I posted on my Facebook page. As a matter of fact, I'll post my entire.
No, pull that shit up. Pull that shit up. You ain't got. It ain't got to be Facebook. Pull that shit up. Let's go.
Hold on.
Pull that
Susan.
shit up.
Webster
Let's go.
University. Webster University. Hold on, boo.
Yeah, go get it. Go get it.
Yes, I will.
Do I need to get my other one, or are you good on that?
Oh my God.
Go get it.
Girl,
Don't say you ain't got it. Don't say you ain't got it. Don't say you ain't got it. Come on now. Get it off the wall. Take it off the wall.
it's right on the wall with my cap and gown.
What you mean?
Nigga,
Get it off the wall. Just take a snapshot of it.
Nigga, it's hold on. Let me get on StreamYard. And your ass is going to unaccredited universities.
I wish Webster University was an uncredited university. You done bumped your head. You done bumped your head 5 times, Bookie Booty.
It say Walden EDU.
Webster University is an accredited university. You don't know what you're talking about, honey. Bookie Booty. George Herbert Walker.
Hold on, boo.
Yeah, boo-boo. Post that shit. Can't nobody see that. All I see is an empty ass book. Nah, I don't want to see no damn hat. You can buy that from Walmart.
All you see is an empty ass book. All you see is an empty ass book, bitch.
You can buy that shit
Hold
from
on,
Walmart.
motherfucker. Everybody shit up on my motherfucking mantelpiece. Me, my kids, all this shit. Everybody.
I don't want to see your
kid.
kid.
I got a
I don't want to see the cap. I
I
don't want to see the cap and gown. You can buy that shit. That's a Halloween costume. I want to see the degree. I want to see the degree.
Okay.
You want me a cap and gown.
Yeah, okay. Here's my commencement book, Goofy.
I don't want to see no commencement.
You want to
Open
see
that
my
bitch up.
name in there?
Why you
want
just
to
can't
see my
post
name?
it?
It matched the degree,
Why you
bitch.
can't just
Y'all
post a
stalking
degree?
asshole. Never would
Why
y'all
you
have
just
my
can't-
motherfucking shit.
See not what you cussing for? What you cussing for? Why you carrying on like that? All you got to do is post the degree.
Y'all ain't finna be
But
fucking
where
baby, y'all
is
You don't utilize your degree.
where is the degree?
You don't utilize your degree.
I thought you said we was doing degree for degree. Did we say degree for degree?
Work, motherfucker. I work. You don't work.
What does that mean? I do work. What you mean I don't work, girl? What do you mean I don't work?
You work on YouTube.
Excuse me?
Okay, boo. Your job is on YouTube. Okay?
Hold on.
YouTube.
Okay, hold on.
Straight
See. Okay, hold on. My job is on YouTube.
Your job is on YouTube. You do not have a job.
I don't have a job. Is that what you
It's on
think?
YouTube.
You think I don't have a
You-
job?
YouTube is your source of income or whatever. Where do you work? You work on YouTube. Okay? And I'm talking
What does
my
that
shit
stand?
because
What does
I'm
that
off work.
What does that stand?
Okay? Girl,
What does
who
that say?
cares? My grandfather was 761st Tank Infantry under General Patton. Motherfucker, what you want
said I
to
don't-
show?
You said I don't work. I am retired. I am retired. I don't have to work.
Good for
I don't-
you.
You
Good
said I don't work.
You.
I am retired.
You're retired.
I am
If you're
retired.
retired, you don't work.
But I do work though.
If you're retired, you don't work. Like I said, you work
let
for
me ask you
YouTube.
this.
You do your YouTube. The
So
fuck
you said,
do?
wait a minute, hold on. So you said I work for YouTube, right?
I said you work doing your YouTube.
So if a person make money, does that mean they work?
Girl, you don't work at a major hospital.
So
You're
so
not
how- how
you're
is
not
that? I don't work.
utilizing
I don't work, but I got paid 100. I don't work, but I got paid 106K. I got paid 106K off of YouTube, but I don't work. This ain't work.
Estimated.
I'm at work now.
Estimated.
This is not no estimated. This 2025 Bookie Booty. This 2025.
Estimated.
Okay, let me prove you wrong then. Let me go on and prove you wrong. See, I'm gonna keep on proving you wrong, and then you're gonna have to give me. You're gonna have to give me something. Okay.
Give me your AdSense payout, cause my channel was monetized too. Show me AdSense payout.
So if I show you my AdSense payout, you gonna believe me then?
Yeah.
Okay.
Because your AdSense payout is what the fuck it is. That's what they actually paying you.
Okay. Well, what you want to see? What you want to see? What you want to see? Huh?
Ooh,
What
show me that shit, girl. Make it big.
No. What you want to see?
Put
What you want to
hit payments. Hit payment.
this year? Okay. Hold on. Oh, not this year. 2025. Previous year.
Break it down on the months.
How do I do that? How do I break it down?
Starting balance. I want to see what they putting in. Because you started with 7996 and you ended with basically, okay, thank you. Make it big. Shit.
Okay. Are we there? Are we good?
We good. Shit.
Okay. All right. I ain't got a lot of you. I ain't got to
I'm making a couple of thousand every month. That's decent.
I ain't got to fake it to make it.
That's decent. You make a couple of thousand because people want to hear your point of view, and that ain't even your Cash App and the rest of that shit. Okay?
Yeah, it sure ain't. It sure ain't.
No, it ain't.
So I ain't got to fake it to make it though. So you said I don't work.
What does that got to do?
But you said I don't work.
I said you don't have a job, and I
No,
said
you actually said I don't work. You actually said I don't work. You didn't say I didn't have a job. You said I don't work. Let's be honest now. You said I don't work.
you don't work when I'm constantly saying you work your little YouTube shit. You do your YouTube.
I'm retired. Why should I have to go to somebody else's job if I can make 106,000 on YouTube? Wouldn't you want to do that?
Not necessarily.
Oh, okay. Well, I enjoy it because guess what? I'm at my home. My housekeepers are out there right now cleaning up my house. And I'm in my robe, sitting in my office, drinking on some coffee and some water. And I'm enjoying myself.
I see that you got a couple of more thousand every month from that 7,000 that was in there from the get-go. It started at $7,996 around there. And then the next month it was.
What are you talking about?
And then it went up to 10,000. So
what are you talking about?
I'm talking about what you actually got paid. Now you
So
just
you,
told it. So y'all just go back to the video and look.
what are you talking about? I made $7,000 for 2 months. The rest of the time, I made $8,000, $9,000, or $10,000 a month. What are you talking about?
Honey, it says ending balance. If you made 8/1/31, ending balance 7,986. September 1st, 2025, $7,842. So that's actually less. Okay.
What are you talking about?
What are you talking about? Now here we go. Earnings, right? It says
Cat got your phone?
through December 31st. So how are you earning 8,500? What date did you earn that? And then it says 8,800. You're not earning 8,500 and 8,800 on a daily basis on no motherfucking ass YouTube.
This is each month, Buki. This is for the whole year. Do you not see January 1st?
January, February, March, April, May, June, July, August, September, October, November, December. I need to see that. I don't think so. That it don't say on those dates you earned that. Okay.
So you don't want to ask me. Okay, taxes. You don't want to ask me. You don't want to ask me to see my AdSense, right?
Yep.
So I brought up my AdSense and I'm showing it to you. And you saying what?
Why is there a minus sign?
Because it's payment. That's what they sent to my account.
Who are you paying?
I ain't pay nobody. That's what they paying me.
Hold on, let me pull my shit up because mine won't.
Yeah, pull your shit up so you will see. I don't know why you trying to a little girl me over here. Girl, I do what I do. I do what I do. You can't believe I make $8,000 a month? You think I
don't have no choice.
Leave
it when I pull my shit up and compare it. Because AdSense is AdSense.
Okay, well, pull your AdSense up. Let me put it on up here and let everybody see how much you bring it home. This is how you shut people up, y'all.
It does do that.
Duh.
Wait a minute. Let me go to my earnings. Where is earnings at? No, it's supposed to be in payment. Hold on. Damn, bitch, you didn't.
Oh, now I gotta be a bitch. Now I gotta be a bitch, and I still ain't seen your degree. I
don't give a fuck. You ain't finna see it with y'all stalking ass.
Now we stalkers.
Anytime
You a trip, though.
No, boo. Anytime motherfuckers is all at my address and shit, y'all some stalkers. Straight.
It's not on your address. It's your address is not on your degree.
Girl, get the fuck out of here. My address is public.
Okay, nevertheless, but you said degree for degree. I showed you the degree. You said degree for degree. I showed you degree. You showed me your cap and gown. You could have got that for Christmas or Halloween somewhere or whatever. But it's all good. All I'm saying is when the time comes, right? When the trial happens, okay? The trial's going to happen and it's going to be an uphill battle for the state. I'm telling you, it is. It looks easy now because she was denied detention twice or maybe even 3 times, I think, at this point, right? But I'm telling you that it's not as easy as you guys think it's going to be. It's not. Because the evidence goes against the witnesses. You guys are not listening to the witnesses. You heard one part of the witness and you took it and ran. Her statement internally contradicts itself. Her own statement contradicts itself.
Okay, Amora, if there were no witnesses proving that Holly intended to cause great bodily harm or death to Ramika is not hard to do when she shot this woman twice and would have shot her more if her gun didn't jam.
If that's the case, what you're saying, then they wouldn't have a self-defense law. If that's the case, they wouldn't have a self-defense law. They have self-defense in cases like this, okay?
Why?
So if
Okay,
there was no witness statements and there was no video footage,
what in
they
the
still have to rely on evidence.
this Trina?
So you on YouTube while you at work? She at work answering a call. You cheating your boss. You cheating your boss. You can't be doing that. She answering work calls while she on YouTube. Ain't that like triple dipping? You can't do that.
I wouldn't never do that. And like I
How
said,
you at work and you on
I did
YouTube?
not say I was at work. Just because I answer my phone professionally, okay, this is Trina. That doesn't mean if I was at work, I wouldn't say just this is Trina.
Okay. Well, it was nice being with you. But I'm here to tell you, your state needs to
But
come
I
up.
expect you make plenty of money so you can keep, helping Holly and putting money on her books because she's gonna be there, right?
You know, when Holly goes over to PT, I'm gonna buy her first pack of honey buns. That's what I'm gonna do for Holly. I'm gonna buy Holly her first pack of honey buns. Okay. Because y'all said she looking kind of thin in court. So since she looking kind of thin, I'm gonna buy her first pack of honey buns. Okay.
And that's sustenance. Can you buy her a hug with her children? Can you buy her?
In due time. Sometimes you have to sacrifice. Now, let me tell you something. During my military service, I've had to sacrifice quite a bit. You know what I'm saying? I had to sacrifice when I was training, and I had to sacrifice when I retired. But not when I retired, when I went to war. But when I came from war, I was able to hug my kiddos, okay? Real tight. So right now, Holly is going through a battle, all right? She's going through a battle because of an unfortunate circumstance. But at the end, she knows that she's going to come home and love on her son, all right? She knows right now, and she's good. I know a lot of you guys are saying she's crying and freaking out and this and the other. Holly is actually good because Holly know at the end of the day what she did was what she.
Amara, if she's good, why does she need to be put in protective custody?
Because of people like you and a bunch of other people that want her neck.
What? I don't even got a channel no more. Why people like me? Why people like me?
The ones that's making threats to her and saying, I wish she rot in hell or I'll beat her ass and things of that nature. You know, it is people in there that has been threatening her life. And you know, she don't need to be mingling with those type of people. So she's going in protective custody because she does not want to have to not be here to, go to trial and beat her case.
To be in protective custody, her attorney.
And one more thing, I heard somebody say that she needs to go ahead and take a plea deal. Holly is not taking a plea deal.
The county don't want no lawsuits. They can't let anybody harm you or you harm yourself, or it is a lawsuit.
No, I believe that somebody might try her, Somebody might try her or whatever. Think that they're some type of hero or whatever. But no, she don't need that in her life. But the thing about it is, in a high-profile case, another reason why she needs to be in protective custody because she doesn't need nobody asking her what happened and she explaining her case to them. She needs to do her case in the court of law, not in no roommates or cellmates. She needs to talk to her attorney and her attorney only. She don't need to be around those people because she may be compelled to speak if she's around too many people. She might get a little comfortable. So in high profile cases, she needs to be set apart.
Oh, so you don't think that's going to be lonely for her?
It may be lonely, but it's okay to give her time to reflect on
Oh,
things that she want to do when she get out. She wants to become a dentist. I think that's an excellent choice.
she will have to get all of that shit expunged from her record.
She can get it expunged. Ain't nothing wrong with that. She can get it expunged. Once she's found not guilty, the expungement is actually free.
But that's not going to happen.
Okay, well, we'll see.
Girl, we'll see. You know where to send that Amazon gift card. Boo, boo, boo.
Girl, I'm gonna send you Amazon gift card with a whole bunch of Kleenex tissue. Okay?
Pablo with. So you might not send me another. You might not send me another $100 gift card because I bought Pablo with it.
Okay.
Yeah,
Kleenex. But no, seriously, I do believe that you guys are jumping the gun with thinking that she is about to rot in prison. I really do think you guys are jumping the gun. And the reason why I say that is because it's not as black and white as you think. Okay. The state has an uphill battle, you know, to disprove self-defense. And that's not going to be an easy task. Okay. It's not going to be and another thing,
you know how
the state's witnesses are, they were both in transit. I don't know why not one of them was there the entire time. They were both in transit. Do you know what that means? They were walking, they were riding, they were pushing, they was driving, they were walking into their job, they were looking out of windows over trees.
Correct.
Yeah, so good luck with that.
And so they need to only say that she intended to cause great bodily harm or death, and it wasn't self-defense. If you pull a 9mm,
they can't just say it wasn't self-defense. They have to prove it.
He just pull a 9mm out. You think Romika is gonna still attack somebody who got a 9mm Glock pulled the fuck out? Who still attacks somebody with a 9mm on them except people in the damn movies?
So who run up on someone with a weapon in their hand?
Girl, ain't nobody ran up on nobody with no weapon in
So how did her body get by her car?
Shit.
How did the body get by Holly car?
She started shooting as soon as Carlos let her go. Why is somebody?
You know that was a fabricated story, right?
You say what?
That was a fabricated story by the witness.
So everybody lying but Holly. Everybody lying.
What do you mean? Only one witness said it, and another witness said a bear hug. But do you know the second witness number 5, only became a witness in December, and this is after witness number 3 came publicly telling her testimony.
So Carlos ain't have his hands on Romika trying to diffuse the situation like he said.
He didn't have her in no headlock.
What did he have?
And at the time of the shooting, no, she ran out of the car.
Obviously, now she ran out the car and got shot. So when she
actually did. She actually did.
So in her running out the car, Holly shot her.
No, she ran out of the car. She ran out of the car on her and swung on her, and that's when she got shot.
And so why was there any soot on Romika since she got shot at?
Okay, so do you know what that means? Soot is when you have the gun pressed against someone's flesh. That's how you get
You could be very close to them, and you've been in the army. Stop playing. Your ass been shot.
Which means that you have to have the gun pressed on them in order for them to receive it.
You ain't gotta have it pressed on it.
Listen. We didn't went down that avenue, that road several times. Listen, soot. Let me show you.
That's how you get 8,000 a month on YouTube, and I don't. Your ass is a good talker, but a good talker ain't finna.
I'm more than a good talker. I know how to comprehend. I know how to read. I know how to understand, and I know how to relay it. A lot of you guys do not know how to comprehend, because if you knew how to comprehend, you would look up yourself and find out that the lack of soot just means that she did not unalive Romika execution style. Okay, she did not press the gun against her face and shoot her weapon. That's what that means. Do you want to ask your Gemini?
The physical character, no. Ask your GPT. Oh,
You don't trust your Lion Gemini anymore?
you can hear that I'm smoking, girl. Damn.
Oh, so you're unhealthy? I didn't know you engage in unhealthy activities.
I definitely smoke.
I don't put those impurities into my body.
I definitely smoke marijuana for my pain. Now, some people like alcohol and do other things. Some people engage in conversation. It's not what you put in your body
Oh, it's not?
that comes out.
I want you to hear something. Hold on. I want you to hear this. While you smoke your marijuana, I want you to hear this.
I hope it's Brazasia.
Okay, here we go.
Question. And you're not crazy for being confused. This is one of those moments where forensic language gets oversimplified online and people run with it. Let's slow it down and clean it up. Number one, what no soot or stippling actually means. When an autopsy says there is no soot, smudging, and no stippling, powder tattooing, it does not automatically mean far away. It only means not a contact or near contact shot. Here's the basic breakdown. Contact / near contact, 0 to 2 inches, soot, stippling, burns, intermediate range, roughly 2 inches to 2 to 3 feet, often no soot, stippling may or may not be present. Distant range, beyond powder reach, no soot, no stippling. Key point, open quote, lack of soot, see you across the parking lot. Close quote, it simply rules out the gun being pressed against or extremely close to the skin. 2. Why the shooter can say she was close, and the autopsy still say not close range, because close in human language is not the same as close range in forensic terms. Examples, someone 2 to 6 feet away, advancing toward you, most people would say she was right there. Forensics would say no soot or stippling present. Both statements can be 100% true at the same time.
Boom.
This is where bloggers mess up. They treat forensic wording like it's everyday speech.
You said she was shot while she was with Deja hair. That's close. How long is this girl hair? We see
So,
her hair in the
exactly.
video.
She was close. Listen. She was close, but the gun was not pressed into her skin.
Does she
It was not
close range?
You just heard what it said. Close range. Close range.
Pulling Holly hair. How close is she to Holly when you saying she was shot pulling Holly hair? How close do you say that is?
That's close. She was close.
Hey,
So that's what it just said. It says that.
how are you pulling hair? How are you
See,
pulling?
that's why I hold the degree and you don't. Because it literally just said it just said it both can be true at the same time. It just said that. It literally just said that, Trina. Did you not hear it? Do you want me to start it over?
I'm not doing no both can be true at the same time. You said
so you don't believe two things can be true at once?
Girl, stop playing with the people.
No, I'm not playing with no people. So wait a minute. Do you want to put it in your Gemini then? Put it in yours. Put it in yours. Put the same thing in yours. Put this right here. Put this. What no soot or stippling actually means. Put that in your Gemini. Put it in there.
This is what I'm putting. They be wrong on my motherfucking typing board, but I bet you people need their prescriptions filled and shit. They be glad I'm typing fast as a fuck. Okay, let you need your oxycodone. Your ass will be glad that you got a motherfucking type like me.
And your AI slow down. Slow ass AI. You need to up to the higher grade. All right, what does that say? It's so little. What did you ask it? I'm sure you
Soot
asked
is
it
a
to some weird.
byproduct of the burn. Very short distance, usually visible within 0 to 12 inches. If hair pulling occurred, you would expect to see heavy soot. If the gun was fired while Romika was holding Quadacia's hair, the smoke would likely deposit on Romika's hand, wrist, or the specific area of her body that was closest to the muzzle. Seeing she was shot in the face and the leg, it would appear there. Okay.
Where did I say that?
The hair.
That shit that. No one said she got shot in the head. What was the question that you put on there? She was shot in the face. She was shot in the face and the thigh.
Shot in the face and the thigh.
Let me see the
should have been on her thigh or her face or both.
Let me see the question that you put in there.
What did she do? Get shot in the thigh and then started running?
No, let me see the question that you put in there.
Oh,
drop down.
Hold on. Hold the fuck on. It's right
Romika
here.
is said to be pulling Quadacia's hair when she was shot. Would there be soot or gunshot residue? See, you put the wrong shit in there. But nevertheless, all I was trying to tell you is soot and the burn marks would be if the gun was pressed against the skin, or you can get soot if it's 0 to 12 inches away. Now, I don't know if Holly was further down. You know, I wasn't there. So all I got to say is there was 2 shots. 3 shots total. 2 shots land.
Was she shot when she was pulling Holly hair or no? Because you said she was shot.
She was shot. To be honest with you, let me just say it like this. When she swung on her, she shot her when she swung on her. But her hair was in Romika's hand. But I don't want to tell the whole thing. I want Attorney Ari to be able to say something. Goddamn.
Man, look, she swung on her and she shot her.
Yeah, I would have done the same thing. You rush up on me and you swing on me, I'm gonna shoot your ass. Yes. I ain't asking no questions. Now, this is after you threatened me. Now, if you ain't threatened me, then if you run up on me, that's a different story. But if you done sent me a whole lot of death threats, yeah. When you run up on me, I probably won't even let you swing on me. I'm probably gonna get you after the second step.
You can't do that shit, girl. You can't say
coming toward me full speed. I don't know what you got to do to me.
Stop where you are. I'ma shoot.
No, I'ma say, I'ma look and you running toward me. I don't know what you about to do. I don't know what you about to do. Yeah, I mean, I'm gonna eliminate the threat. That's a threat on my life.
I don't have no video of the evidence, and I ain't see that Romika was.
You said while Holly is not out, then you got to rewind the tape. We already done went over that. You late.
There's no video of the incident. It's no witnesses that said Romika ran up on Holly, except for one, which is
they wasn't there because they wasn't.
Which was Carlos, and he
wasn't there.
And he said it. He was there, but he ain't mentioned it.
Carlos was there.
Carlos was there, but he ain't say shit till 2 hours later.
Well, how about the witness? How about witness number 3 didn't say until a day later that Holly aggressive beat on the hood. She didn't until 3 days later. Now what?
A day or 3 days later?
It was a few days later.
How many days?
I don't know. I don't know if it was 1 or 2.
then if you don't know if it was 1 or 2, how do you know it was?
It wasn't that day because Ari said it in court. She said that her testimony changed from when she was standing out there on body camera versus when she went down a few days later. Oh, a day later. Okay, I'm sorry, a day later.
Okay,
What she
so
told the police the day of the incident, she told them something different the
she
next
gave
day.
a day later.
Platinum bracelet. Let me say this to you. You have absolutely no idea what you're talking about whatsoever. You're wrong about this case. The girl is actually worse than what has been put out here on the internet. So you are absolutely wrong. As you often
And so if Ari is planning to use the lynch law as a defense, that's not going to work.
Not the lynch law. It's called self-defense law.
Well, if you're going to talk about Romika's prior behavior and character,
yeah, that will come up. Unfortunately, it will. It will.
And
it
they're
has
the same
to.
size, the same height, and Quadesia had a gun.
And you know, listen to the lie. Listen to this lie right here. Listen to this lie. Let me read this. She says, "Not true, Amora. You're repeating all lies. Carlos has blinded you. I can't wait until those satellite imageries are introduced into court. This is sad as hell how his mother is being disparaged. First of all, you have no idea what you're talking about. You do not know Romika whatsoever. That's one. Hold on, let me tell her right quick. Give me a second. And then there is no satellite imagery. You bullshitted the whole way through the LaTruth story with your bullshit of the FBI, the TBI, the CBI, the MBI, and the LBI coming to get the LaTruth family, and they ain't never came. You should really stop your lies. You've been lying for so long. You really don't want me to come out here and tell people how you really, really, really have been lying. You don't even want me to come out here and tell all about these bounced ass checks and shit. I've been really, really, really closing my lips up on you. You lie a lot. So cut it the fuck out. Cut it the fuck out. And I mean that. Now just cut it out. Go ahead. Sorry about that. I'm just sick of her always lying. She lied the whole fucking way through the goddamn LaTruth story with them damn lies. I'm sick of this shit. Now go ahead, Trina.
Yeah, so man, something went on that should not have went on. Should not have shot Romika.
I understand what you're saying. I understand when you say she shouldn't have, because that's how you feel. But by law, all I'm saying to you is by law, she has a reasonable defense. And we have to wait to see if the state can disprove that defense. If not, she will walk.
And I know that. I'm not saying that her defense isn't reasonable. What else could she claim? Insanity? Like, yeah, well, that's a reasonable.
This is better than insanity.
I went through. I'm pregnant. I'm still going to do postpartum for the last baby. I'm pleading insanity. So yeah, she's going to plead self-defense.
She didn't plead insanity, but she's definitely pleading self-defense. And I think that she has absolutely. I think she has a 99% chance of winning, of being acquitted.
And I feel she got a 99.9% chance of going to jail, and she needs to cop a plea. And maybe after Ari has that,
why would she do that? Why would she do a plea?
When Ari has the 402 conference with the judge, you know what the 402 conference is?
I'm sure you're gonna tell me.
Yes, I am. The 402 conference is when Ari, the prosecutor, and judge are in the judge's chambers, and the judge he's straight up with them. He tells them this is how much time she's facing when I sentence her, and she's found guilty after the trial, and this is how much time she'll be facing if she takes a plea of guilty right now.
She's not taking a plea. Listen, let me tell you something.
Hold on,
Let me tell you
Amora.
something.
And she needs to consider what Ari gets from the discovery and what is said in that 402 conference before she decides if she's going to take a plea deal or a plea of guilty.
She already know what happened. Why would she take a plea? She was there. She knows what happened. So here's the thing. She doesn't need to wait for discovery. She was there.
Amora, she has no idea the amount of information that has been
does.
On her.
It doesn't matter the amount of information.
Lying
if there was a tape,
Amora, let me tell you, Amora, listen and stop going to war, Captain. Hold on. I'm saying, shit, I feel like I'm talking to my granddaddy. As I told you, he was 761st Tank Infantry under General Patton. You got to make that.
You probably didn't know your granddaddy. Your mama told you that. Your mama told you that.
What do you mean? My granddaddy just died in 2014. The fuck is wrong with you, Shorty?
Okay. All right. Well, 2014 was 12 years ago.
Stand down.
But listen, Trina.
World War II was how long ago? How long General Patton been dead? Now let me explain this to you.
No. Listen, you have explained enough. Listen to this. If 12 jurors convict her of first-degree murder, she will go to the Supreme Court and she will win. Boom. There we go.
Amora.
But 12 jurors are not going to convict her.
Ari doesn't have the discovery.
It doesn't matter what the discovery is. Like I said, she was there. Holly was there. She knows what the hell happened. She was there. What she need a discovery for?
She needs to know what other evidence was gathered on her goofy ass.
It don't matter what evidence. It doesn't matter. She knows that she did that in self-defense. It doesn't matter.
Oh, okay.
Yeah, it really was self-defense.
Mm-hmm. Okay.
It really was. Yeah. So unless your state attorney can disapprove it, which he can't.
Carlos was already defending her. He already had her in a headlock, and they said that he was hitting her in the back with her own damn car door. So
that didn't happen.
That's
a lie. The witness lied. The witness lied. And guess what? The fact that the witness said that, why wasn't captured on camera on the CTA bus? The CTA does have footage, you know. The CTA does have footage, and it shows him standing there and Romika standing there. Ain't also no damn door being slammed on her. Why didn't the CTA pick that up?
Have you seen the footage?
No, I haven't.
Well, you can't attest to that.
But I know someone that has.
Oh.
Okay, well, you're going to see it if you go to court, and you should. Y'all need to come in here? Come on. My housekeeper in here. I'm going to have to take y'all back outside. You can come on in. I'm going to take you outside and show you my nice ass pool, Trina. We're going to do pool for pool?
Hell no, because I ain't got no pool.
You can come on in.
I ain't got no motherfucking pool. A pool ain't required to be intelligent. A pool ain't required for her ass to be proven guilty of first-degree murder either. But if I'm ever down, look you up. Now what the hell? I know this heifer ain't leave me on her live by myself like I'm the goddamn housekeeper. Ain't that about some shit?
I'm back.
Hell no.
Oh, baby.
I know you didn't try to make me work.
Okay, I'm back. Can y'all hear me?
Okay. Yeah, we can hear you.
Can y'all hear me? All right. They're cleaning the office. I've been on this thing for 4 hours. My husband out here
In
killing
31
y'all.
minutes. In 31 minutes.
So again, next time you
So
come
you
up
should-
here, this is what I want you to do.
You
I
should
want you to
invite.
research probable cause, not probable cause, I'm sorry, beyond a reasonable
What you
doubt.
should do is have one of your members come spend the week with you. Since they attribute $8,000 a month for you to have your nice lifestyle, invite one of them to come spend the week with you, girl.
I let one of them stay 3 days and she betrayed me like a motherfucker. So I'm scared. I'm scared of people now. I'm scared to bring people to my house.
Wait, I'ma come when my kids go to college. I'ma do you like the lady who was on Facebook and shit.
Well,
I'ma
come on, and I'm a barbecue for you, okay? I'm gonna barbecue for you. You come on.
I'm gonna have you film me. You gonna film me trying to put me the fuck out. I don't eat pork.
Okay, I'll make you some chicken salad sandwiches.
I don't think you can cook better than me, Amora. I think you
I
should.
might not, but I can cater some shit for you.
Right. The only thing you know how to make is reservations, nigga. I know how to cook. You've been in the army since you was 19. I've been married since I was 19 to an officer in the Navy. Okay. Charles Logan III on the USS Bellawood. Okay. So I'm about that squid life. Yes, I am. Even though all my family is Army. And
You
I
said
recently
you about that squid life. Actually,
I'm about that squid life, okay? So Amora she may not even know how to swim because she been in the Army, okay?
I did 7 years in the Navy first before I joined the Army.
So you was at Great Lakes for your basic.
I was. Great Lakes, I sure was.
Yeah.
Yep. Matter of fact, I was the first female battalion that integrated with the guys. Because before I joined, it was males went to all males boot camp and females went to all females. My class was the first integrated class.
Wow.
So I went with the boys. Well, the boys and the girls.
Wow.
Yep. First integrated class. So yeah, so I know a little bit about that squid life. I had to pass the swim test. I can't swim now though. I'm too old to know how to swim now though. But I know how to survive.
Hell yeah, being the first one, the first, group to be, cohabitating with men. They have a lot of sexual abuse allegations, in the fucking 2000s. So I can imagine then what they was on.
But I was grown as fuck. I was 22 already. So when nobody sexually abusing me.
Yeah, but shit.
I would have whooped their ass. I would have pulled out my handgun.
Yeah, but if you know what I'm saying, if you by yourself on base trying to get somewhere, then you by yourself on base. And that's a huge base. You know what I'm saying? And shit can happen. You know what I mean? I'm not talking about your run-of-the-mill, sexual, not necessarily, abuse, because
it's a lot of it in the military. I ain't gonna sit here and deny it. It's a lot.
Yeah, it's women missing right now. Come on. It's women dead and missing shit. Black men arrested in the military. Shit.
Yeah.
Yeah, so shit happens.
Yeah, they got their level of crimes.
But why don't you talk to the people about the gay bomb?
About the what?
The gay bomb and the heart machine.
I don't know nothing about that.
Research, girl. You can go all day in the dirty deeds of the military, but shit, if you still getting your retirement money, let me do it.
Yeah, but no, seriously.
But when you get
let me
off,
ask you something though, Trina. Do you cover other cases other than the Holly and Ramika?
Absolutely.
Oh, you do? Okay, I didn't know that.
First of all,
because I thought a lot
of
Ramika. It seems like a lot of Ramika supporters. That's all they cover is Ramika. Like they don't have no other content outside of just Ramika.
No, mostly that's why my channel was Politricans and Leadership. My coverage was mostly the local politicians. My court case, 19 CV 7266, when I sued the village of Dalton in federal court and won pro se. Okay.
Oh, did you? Okay.
Absolutely. So I know federal law very well. You know what I mean? So as far as state law, I think I can handle that too. That's why I feel like they have such a strong case. That like my aunt was the Port Authority attorney of the city of New York. So she don't have no kids. You know what I'm saying? I am basically her kid. I'm the oldest of 31 grandkids. I love the law, but medicine is my major. You know what I mean? But at least through the Romika case, and she's 70 years old, she's like totally willing to support me in my application for medical school. She was like, just make damn sure that DePaul is accredited. I don't think DePaul is accredited. I'm like, it is accredited, but she graduated from Columbia School of Law in New York. You know what I mean?
Well, I think you should go to law school and I think you should take up criminal law. And I think you're going to learn about self-defense too. You know what I'm saying?
No,
right now, I don't think you know too much about self-defense.
I love to argue, so I think I'll follow my aunt's advice and be a litigator, and not deal with criminal law and be miserable my whole life. You know what I mean?
Why you say miserable? You can save people's lives like Holly.
But you're under the assumption that I would be a defense attorney and not a prosecutor.
Well, I mean, a litigator is just somebody that fights cases in court.
A litigator is basically the attorney that the attorney that finds the argument and fights that argument in court, but not necessarily having to be in court, but the person that finds the argument of the case.
Yeah.
Had everybody messed up, Amora. They was like, how are you in federal court about a water bill?
Did you win any money?
That's municipal court. Absolutely.
Oh, I didn't know you can win money in federal court.
Yeah.
Are they done? Okay.
What do you think federal court is about?
I mean, hell, to be honest with you, I don't know.
What if somebody violates your federal rights or commits a federal, like if someone takes title to your home, you would be most likely in federal court.
Oh. Yeah, to be honest with you, I don't know a whole lot about court cases, although I do start school next month. I'm get another master's. I'm doing my master's in legal studies because now I'm interested in them, Since I've been researching so much on this Holly case, I'm very interested in the law now and how this is going to turn out. I don't want to be a lawyer. I feel like
you got a master's in art. You say the school accredited. Why wouldn't you just? I got my undergrad. I could just do the 2 years like Ari did and get my law degree. Granted that I don't want a
law degree though because I don't want to practice. I just want to do case analysis on YouTube. Believe it or not, a lot of lawyers have literally stopped practicing
you can
law.
Go to Harvard School of Law and do all the online free certificates. Unless you got military money to spend, and by all means, you know what I mean? Have them spend the money and just, kick your feet up and chill. But it's a lot of courses you can take online for free. Like you don't get a degree.
To be honest with you, I really don't need it. I just want a degree. I want it behind me. I just want it. However, I will say this. A lot of attorneys have stopped practicing and are literally teaching different, they do legal analysis on YouTube and make way more money than they would as a lawyer. Because a lot of people think lawyers are high paid. I mean, criminal defense maybe, but lawyers are really, they don't make that much money. They're not high paid. There's some lawyers only make $80K, depending on where you at.
Yeah, that would be like at the state attorney office, just breaking into, you know what I mean, getting a job or whatever.
Yeah, I think that the Illinois state attorney only make $80K.
So
that's why they wasting their time with this case.
Look, girl, this case is
it's gonna become a case study.
You will hope that where's the defense? You
Hey, let me
if
ask you
Bobby
something.
looks
Have you
like
heard of
right?
the people versus McGraw?
I don't know that case, so I can't
I
refer back.
want you to look it up because it's in the state of Illinois. It's from your state. McGraw actually killed a police officer, but this was after the police officer was slapping him and punching him or whatever. So he say, right? There's no video footage of it, but he said the police officer was slapping him and punching him in the head during a little small traffic stop. Right? It wasn't even a traffic stop. The cop was in civilian clothing, right? And the guy swiped his car like very basic swipe, $5 to $20 worth of damage. But this was in 1958, so I don't know if $5 to $20 was a lot back then. I don't think so, but nevertheless, $5 to $20 worth of damage. But the cop got mad, and they got into an argument, and the cop started basically beating his ass, punching him and shit or whatever. So he was like, "Yeah, you only doing this because you got your weapon on you." So the cop took his weapon off and put it in his car. And so he kept beating the guy. However, the guy took off and ran and got his gun out his car and shot him 6 times with it. And he beat his case. Well, he didn't initially beat it. He lost in the he said it was self-defense. He lost in the state court and he took it up to Supreme Court and he won and it was overturned. They convicted him and everything. The jury convicted him and they took it to the appeal and he won his case. And the reason why he won is because they were trying the case as if it was the proof of the defendant to prove it was self-defense. And they said because he didn't prove it was self-defense, that was the jury instruction that was given. And because he didn't prove it was self-defense, then he was found guilty. But when it went up to the appellate, they was like, no, it's up to the state to disprove self-defense. And so because the state could not disprove self-defense beyond a reasonable doubt, he's a free man.
Or was it because the judge gave improper jury instructions?
It was improper jury instructions, but the state said that they didn't want to retry it because they could not prove that it wasn't self-defense beyond a reasonable doubt. That's why I say reasonable doubt is actually huge.
It's a whole television show that all the black women love called Reasonable Doubt, right? With
Well, I have not seen that, but I would be interested in seeing it because I do want to learn everything.
Over sexualized, so I couldn't really get into it. You know, I don't feel like black.
I thought it was about court.
Has to be a lead attorney, and every other 15 minutes she humping, and you know she just got to get her beast on. Like, can we keep it corporate? You know what I mean? But that's just the prove to me. I also miss years of Games of Thrones because I'm like the incest sick shit. I cannot, you know. It's like, you know, you fast forward that part and you back at the show, you know.
So Netta says all cases are different, so you can't I think you mean so you can't justify this case by them. So Netta, that's what case law is for. It's for you to reference that case when trying to prove your case. So when you say that it's different, of course it's different, but that's what case law does. Okay. So I don't know if you knew that, but they get a prior case, and they try to use that to win their case. All right. Even there's no case out here that's completely, absolutely alike.
And
okay?
so, Amora, can
different.
I ask a personal question?
Yeah.
Does your husband have children with other women?
Yes, he does.
He does, and
yeah, we don't have no kids together.
Y'all don't. Oh, that's interesting.
Yeah.
Well, that's different because your children aren't with him and his children aren't with you. So that's a whole.
Our kids grown as fuck. I'm old. I'm 53 years old. Our kids is grown and successful. We ain't got no kids in this house. We here by ourselves.
Okay, that's totally different. So you guys got married later in life. After you guys had grown children.
Well, no, we've been together for 18 years, but he's not my daughter's biological father, but she calls him dad. But our kids are grown now. They're not like, yeah, we've been together ever since my daughter was 6 years old, and she's 24 now.
Okay. And had you been married before this?
Yes,
And were you married a long time?
No, 4 years. I've been married twice actually. 4 years the first time and 7 the second time. My whole adult life mainly was marriage. I've been married mainly my entire adult life. Outside of 6 years, I was single for 6 years of my adult life, and I've been married.
I got married at 19. And
I got married at 18.
yeah, and then we divorced when I was like 30. Okay. And then I was engaged to someone else, but me and his mama didn't get along. I was that black bitch like forever. You know what I'm saying? And then I was still messing around with the investment banker who I used to date, but I never took serious. And then I met my children's dad in like 2006 or whatever. And then we had, cohabitated for 17 years. You know what I mean? And it's just so weird. Like, I don't think I want to get married again.
Let me ask you this.
But it's
where you
it's somebody that I like. I would though.
Let me
Go
ask
ahead.
you this. So in the Holly and the Romika situation, right? If because I hear a lot of people say Holly was jealous, she wanted him to herself. If Romika was truly over truly over Carlos and didn't want to be with him and this, that, and the other, do you really think that she would want to fight his current girlfriend?
If you call the damn DCFS on me, hell yeah, I wouldn't give it. Look, it wouldn't. I don't care if you my cousin, my sister, my mama. Yeah, I'm gonna be on here the next time I see you. What the hell wrong with you?
But was that proven? I don't know if that was proven. I only heard it through you guys.
On that girl.
But
you know what I'm saying?
But was that proven that she did that?
Come on now.
No, I'm asking. Was it proven? Because I heard it.
Out. Now, Mora, outside of that, she was talking hella shit.
I mean,
they both was
talking.
They both was talking
so would you
shit.
Want to fight somebody over talking shit though?
Are you going to shoot somebody over talking shit?
No, I wouldn't. I wouldn't shoot nobody over talking shit. But would you want to fight someone over talking shit?
Let me ask you this: unless absolutely necessary, you wouldn't shoot one of your husband's baby mamas.
No, but I wouldn't want one of my husbands.
No, she would have to be doing some. If one of them just came over your house, right, and cussed you out and jumped in the pool, you wouldn't shoot her.
But that's cussing me out and jumping in the pool. But is she running up on me? Is she has she wished death on my life? And then you seen her in public in a neutral territory, and she ran up on you. You would just immediately shoot her. And he's standing right there. He done already put her in the headlock, put her ass back in the car. You wouldn't leave Amora and go home? No, she swing on me. That's it. I'm going to defend myself.
Like you have her on the Texas streets.
If she swung on me after saying that she's going to unalive me and my child, yeah, no, I'm going to defend myself. You're gonna defend yourself,
Amora. I'm talking about saying you ain't ever went to the army. You ain't ever went to the army in your life. Your first line of self-defense would be to shoot her for swinging on you.
Now, see, me personally, I could kill you with my hands, but I mean, I probably would just use my weapon now, but my younger days, I probably would have just killed you with my hands.
I said take the army out of it. So
But I
without
would
your
neutralize.
military
Let me just
training,
say it like this: I would neutralize the threat. However that's done, I would neutralize the threat. I mean, I gotta save my life. Why wouldn't
what
I save my
type
life?
of threat?
Say what now?
Girl, you know damn well somebody swinging on you is not about your life. Your life ain't in danger because this girl done swung on you unless she's swinging on you with a blade, with a knife. If she's swinging on you with a knife, then hell yeah, your life in danger. If she's
But how
swinging
do I
on you
know
with
she
your
don't
fist,
have
your
one?
life ain't.
How do I know she doesn't have one?
Oh, you know
Seriously,
how you
if
know,
somebody run
Amora?
up on you,
You know,
if somebody
you
is
know,
running up
Amora,
on you
because you got a
fast,
9mm Glock in your hand, and you can make anybody do what you want them to do with a 9mm Glock in your hand. With a 9mm, he ain't have to put his hands on her or nobody else. She can say, "Bitch, get back up in that motherfucking car and move around." She ain't got no weapon. She finna move the fuck around. She is
I
not
don't think
finna
so.
say, "Oh no, no gun
So let
on
me ask
me."
you this:
What's up,
if
bitch?
that's
You
the
pulled a
case,
gun on me? Come on now.
so listen to this. If that's the case, what you're saying, if what you're saying is true, right? Then that means witness number 3 saying that while Romika was in the headlock. Now I'm telling you what witness number 3 said. While Romika was in the headlock, Holly said, "I'm gonna go get my gun," right? Or Carlos said he's gonna go get her gun or whatever, right? Or "I'm gonna go shoot you, bitch." So if the witness is telling the truth and she said that Holly went around and got her gun out the car, then at that point she knew that Holly had a weapon, right? If she was telling the truth, if we buy that version, because you guys want to buy so much of witness number 3's version. If we're buying her version, then that means she knew Holly had a weapon, right?
Oh, when the witness said that Carlos said she going to get her gun, he
Right.
don't, she don't know that until she actually see it.
But if she went and got the gun, where did she put it when she went and got it? In her socks?
When Carlos yelled, she's going to get her gun, you want to know where Holly put it?
No. So the witness
And
said
she's going to
she
get
went.
it. She doesn't. If he's yelling, she's going to get it. Then
Right.
obviously she does not have it.
So what I'm saying to you is, if we buy witness number 3's statement, she said she's going to get her gun. Then she said she left and went to the passenger side of her vehicle and got her gun. If that's the case, and then she said she came back with the gun, right? So if that's the case, then that means Romika knew she had it, right?
Came back from where? She went in her vehicle and got the gun. And where did she go
So,
to
so the
come back
wit.
from?
So did you hear the witness statement?
You just told me the statement. You said that she.
So the statement said that she said, "I'm gonna shoot you, bitch," right? And then the witness said that Carlos said, see, she about to go get her gun. And this is all while Romika was supposed to have been in a headlock. Now, this is your
Hey,
witness now.
Paul.
This is your witness number 3.
Carlos got Romika in the headlock.
Your
And
witness number 3 said this.
according to witness number 3, Carlos
Uh-huh.
has Romika in the headlock. According to witness number 3, Holly
Right.
states, "I'm going to get my gun, bitch." According to witness
I'm gonna
number
shoot you,
3,
bitch.
Carlos says, "See, she going to get her gun." And
Right.
so a person going to get something means that they do not have it at the time. And
But that's
why?
not my question. My question
What's your
is
question?
you saying she wouldn't have run up if she saw the Glock 9, right? I'm
Correct.
trying to
I
say,
just said her
so
going
why
to
did she
get
run
it.
up?
She
Why
did
did
not
she run
have
up
it.
why did she run up if witness number 3 testimony is true
Uh-huh.
and she says, "I'm gonna shoot you, bitch," and Carlos says, "See, she about to go get her gun," and then she goes to her car, goes to the passenger side, take her weapon out, and then come up and stand close to her, and then Romika wiggle out of a headlock. Now this is per witness number 3, and then
Mhm.
all of a sudden Holly pops her. Now, this is if we believe witness number 3. That means that she knew.
If witness number 3 is contrary to what you stated, that Romika had Holly by the hair and Holly shot her
After running up on her. But I'm saying to you, if we are to believe a partial of witness number 3 testimony, if we are to believe that, then we must believe that Romika knew Holly had a weapon.
She knew Holly had a weapon when Holly shot her. No,
but you're not listening. You're not.
Listen to me. You said that the witness stated that Holly said, "I'm going to get my gun, bitch." If you're going to get something,
no, she
do
is
not.
Okay.
Carlos is saying she's going to get her gun. That's the second affirmation that she does not have the gun. She's saying she doesn't. I'm going to get my gun. That means she doesn't have it. Carlos saying she doesn't have her gun because he's saying she's going to get her gun.
So do you understand what I'm asking, though?
What I'm
asking is,
because you're basically saying that Romika was aware because Holly said she's going to get her gun and Carlos said she was going to get her gun. So how the hell she didn't know that's what she was going to do?
Exactly. So you said that
because she never met her a day in her life, Amora, until
No. You said she wouldn't run up on her. You said that she wouldn't run up on her if she knew she had a gun.
Run up on her with that gun. That's right. And how much time did she have to run up on her in between her saying she's going to get her gun, Carlos saying she's going to get her gun, and her actually going to get her gun and turning around and shooting her?
So what I'm saying to you is, you said she wouldn't run up on her if she knew she had a weapon. And I'm just telling you, if she knew she had a weapon, because witness number 3 is basically saying she knew she had a weapon.
No, witness number 3 is saying that Holly said she was going to get her gun. Carlos said she was going to get her gun. And then she got that gun and shot Romika. That's what the witness said. Okay. I'm saying if Holly had just went and got that gun like she said she was going to do, and Carlos said she was going to do, and not fired upon Romika, but give Romika time to adjust her eyesight and see that this motherfucker, she's standing there with a 9mm in her hand, I'm sure Romika would have gotten her vehicle and either called the police or left.
Okay.
That's all I said.
Yeah, I don't think she said, Amora, don't forget we have 35 pages to read. Yeah, okay. Yeah, so we are covering another case, and so I'm gonna have to end this call because we have another case.
A few hours to read 35 pages. You need hooked on 5.
Well, I mean, it's not even 35 pages. It's 35. It is 35 pages. It is 35 pages. Oh my God.
But the pool and the crib, it really made me want to concede and get married once again because that's the way I live life. Honey, I'm talking about Amora. I don't want to stop smoking my weed. Shit, I like my weed. Hey, I like my motherfucking weed. I like being able to be loud and cuss and talk.
How are you able to smoke weed and you work in the medical field? I mean, I'm just curious.
I'm not working. I'm sick. I have heart.
Oh, I thought you said you worked in the medical field. My bad.
I have a hole in the valve of my heart.
Oh shit.
Yes.
She said she like me.
I have these motherfuckers. They didn't get the girl look. These people gave me an injection for pain in my shoulder as I'm having a heart attack. Isn't God good? Because they're fucking crazy.
Oh my. Okay.
Yeah. So
Well,
I'm off. I'm off right now. Okay. Thank God
okay.
that I put in work, and I believe in private insurers. Okay. I
Okay.
can't believe I'm wasting my time arguing on YouTube when I know this man is so private. And granted, oh my goodness. But anyway, I live alone. This is my home, and I have the freedom to publicly embarrass myself at will without attachment to any other individual. Okay? Because I'm my own whole person. All right. And so that's how I'm gonna call it. And you know,
Well, I hope you get married one day.
I can always marry my kid's dad. He lives in Beverly right now. You know what I'm saying? Family from the area. You know what I'm saying? So hey, no. I really like my freedom. It is really, these men really have, well, my kid's dad, I'm not gonna even lie, he don't have rules involved like that, but I'm tired of dealing with you thirsty females because he's 6'7" with hazel eyes and red hair, and he's balding, by the way, now, ladies. But yeah, I'm sick of that thirsty part. I'm sick of that thirsty part. I'm like, oh, you see, and then it's like Amora, they can push it out, but they can't take it. Because I'm like, shit, I ain't finna say shit. What I am gonna do is fuck with him. Okay.
Well, let me ask you something. How old are you?
I'm literally 50. What? I'm 53.
And your guy is still cheating?
Well, not technically, because I have been messing with this guy. Like, I literally have been sleeping with this man and spending the night for the past 2 years. And I was transparent and honest about it. Because I feel like if I'm fucking around, you're gonna be the first person to know. I'm gonna start with the warning. And it's very, very blunt. I asked him, do you want me to start fucking on you? Because if I'm not happy, you know what I mean? Because you want to argue every day for stupid shit. Okay? I mean stupid shit. And then be crying in the doorway in the middle of the night. And then I gotta answer and be the bad guy to why we're not married after 17 years. Because you a hoe, and I choose not to respond. I choose to be a hoe too.
Oh Lord, girl. That's that
We
weird.
went to Chicago on the summer. Is you crazy? Why be mad and end up arguing and shoot? Girl, shit. You baby. I wish you would. I wish you, honey, please. I was dating my ass off, but I had, you know what I'm saying? We had small children. You see what I mean? It's a different ball game with teenage children. You see what I'm saying? I ain't finna go to jail for spending the night out, and I got a 16 and 17-year-old, and I done left the crib at 10 p.m. and I done came back at 7 a.m.
Child, anybody got time to be hoeing around? But Trina, I'm gonna have to let you go because I really need to go over these 35 pages.
Absolutely not. But you shit on me, I'ma shit on you. But thank you, and more. Have a good day, and I'm glad you make that money so you can send Holly some, honey. Keep hope alive.
Yep, I'm gonna buy her some honey buns. All right, Trina. You have a great day, though. Okay.
Have a good day.
All right, you too. Bye-bye.
Bye.
All right, you guys. Sorry about that, but I don't know. Maybe I thought I could get not even change her mind, but just get her to understand the reasonable doubt and the self-defense. But she's not there yet. But y'all, wait a minute. Okay, so I'm gonna start another live. But it looks like not only did he add other texts, he added the dates. So it looked like he just went through his phone and added the, oh my goodness. Oh yeah, Valencia, he put you out there, girl. Oh my goodness. He even added the receipts that she sent to other people. Lord Jesus Christ. All right, I'm going to have to start another live, but y'all give me a moment. Oh my goodness, y'all. Okay, so we're going to take a break and let me get some lunch or whatever. I'm not going to do it right now, y'all, because it's a lot. Hold on, but let me go on and set it up. So the truth is not playing with this lady. Miss Season, I know she is over there burying her head in the damn sandbox, because it ain't no way I would allow this man to, man, I would have put it all on the floor. It ain't no way he would have been able to hold nothing over my head. But nevertheless, y'all, I'm going to come back tonight. Let me give y'all a big shout out for those that supported this live stream. But I've been on 5 hours. Jesus, Lord. Woo, Tolly T, thank you so much. I am Glenn. Thank you. Jamie G, thank you. Kimberly, thank you. Kimberly T, thank you. Vera, Tammy B, Wayne, and Quane, thank you. Troy Parks, thank you. Candy Girl, thank you. Troy, thank you. Rita, thank you. Wind Down with Shabola, thank you, girl. Tamira, thank you. Nell, thank you. Nell, thank you. Nell, thank you. What was y'all saying? She said, and she is no longer here. She was unhinged. Click. Sweet Tea, thank you. Joanne, thank you, baby. Nell, thank you. Candy Girl, thank you. Nell, thank you. Barbara Clark, thank you, honey. 200K. Thank you, baby. 200K again. Thank you, love. Nell, thank you. Lady B, thank you. Lady B, thank you. Nell. C Page, Nell. Vera, thank you. Amor has been very respectful, and this guest needs to do the same and pipe down. Y'all know she high spirited. Thank you, Sweet Berry. Nell, thank you. C Page, thank you. Nell says sick of her. She listening to respond, not understand. I miss y'all on this one. Thank you, Nell. Can you mute her permanently? Y'all wanted Trina gone. Thank you, Nell. Thank you, girl. Thank you, Candy Girl. Thank you. Nell, thank you. Tanya, thank you. Tolly T, thank you. Monica, thank you. She said, more clap back at this female. She's slow as fuck. Thank you, Tammy B. Thank you, Carrie, with 2 degrees, girl. 2 degrees. We 2 degree family over here. Actually, we 4 degree family over here. About to be 5 degree. Actually, well, anyway. Thank you, Nell. Thank you, C Page. Thank you, Nell. Nell is coming through. Thank you, Boca Mosa. This is straight up professionalism. Your master is in legal study awaits you, sister. Oh, thank you, girl. Oh, wow. Thank you, Barbara. Girl, still more to go. Thank you, Barbara. How I missed that, girl. Child, I must have been running my mouth for real. Thank you so much, Barbara. Thank you, Nell. Thank you, Chandra. Thank you, or Shonda. I always say your name wrong. Thank you, baby. Thank you, Nell. Thank you, Porter J. Thank you, Margot. I forgot Margot. Thank you, Margot, baby. Thank you, Nell. Thank you, Candy. Thank you, 200K. Nell again. Nell coming through with the 199. She like, look, we so tired, Candy. She trying to get personal info. So y'all know my life is an open book. Thank you, Celeste. Amora, no children on your panel, please. You show her grace when she could not produce. Listen, I was trying not to listen. I'm trying to be more understanding, you know. Thank you, Carrie, with 2 degrees. Amora, you must be bored today because ain't no way you entertaining this woman ignorant. She couldn't produce a degree, for God's sake. Y'all funny. Thank you, Nell. Thank you, 200K. Listen, thank y'all. I already have the live set. I just got to change the thumbnail. I'm going to change it to something different. But I have the live set, y'all. OMG. So it looks like Robert is trying to beat her to the punch and releasing everything. He like, lottie dottie, everybody. Y'all want to know, I'm going to tell y'all everything. Now, I don't know if somebody told him to do that, but baby, he releasing everything. I got to go check on Vivica right quick and find out if she okay. Let me drop this link. Y'all go ahead and at least thumbs up this video. The one that I just dropped, the one that's coming up at 6:30. Go ahead and thumbs up and set your notification bell so you will not be late. But we are coming back at 6:30, you guys, 6:30 my time. And baby, I got to go check on Vivica right quick because I know her heart is pumping hard. Because baby, when I tell you, let me show you a little snippet right quick. When I tell you this Joker, he released all the in-betweens that she left out, baby. He released the in-betweens that she left out. And then it said Vivica's second phone. Lord. Yeah, she didn't give us everything. And he got dates. So it looked like she was trying to hide something, y'all. And I'm going to tell you, I don't really like that. I don't like people that be trying to hide stuff, only showing little small shit. You know what I'm saying? So anyway, but she may say it wasn't relevant. Okay. She said, don't forget the watermark. Okay, I will. She may say it wasn't relevant to the case, but we're going to find out if it was relevant or not at 6:30. Okay. I want y'all to come on back here at 6:30. Have your little Coca-Cola or something already ready. All right. But we're going to find out. She says, oh, she left. I thought he deleted messages. Wow. Listen, I don't know if he did. We're going to find out at 6:30. Okay. She said Mika made a video saying he did call her, but it was by mistake when he was getting his receipts out of his phone. And I believe it. You believe it was by mistake? Well, baby, let me tell you, we gonna, she said, girl, I'm in the bushes now. Ha ha ha. Listen, we are gonna go over it, okay? We're gonna go over it at 6:30, and baby, but I'm gonna read them and I want to go over there and peek at her face because baby, I know she like, damn, ain't nobody told you to release all this. Oh, child. Anyway, she said this was a lot or more. Don't do this to us again. Okay, I won't. But y'all get y'all some rest. Grab y'all a sandwich. I'm gonna go get me something to eat as well, and I will be back at 6:30. Okay. Love y'all. She said, I enjoyed myself. Amora definitely is the GOAT. I am. Love y'all. Hit that thumbs up button and I'm going to talk to y'all shortly. Bye, y'all.
Because they can't make $1 without mentioning down one of our names.
Yay!
She kept talking about
We
that
got these
family.
hoes over there.
She kept talking about that family. She kept talking
Internet
about that
gangsters.
family. She kept talking about that family. She kept talking about that family. That family. She kept talking about that family. Talking about that family.
These motherfuckers that we want to listen. Because they can't make $1 without mentioning down one of our names.